All right, we're going to do just one administrative task before we get into our 1 p.m. docket. So just sit tight for a few minutes. We have one item on the general meeting docket, 2024-101, 6224 Blackstone Avenue, Daniel Goldman. This was heard on August 20th, and the board wanted to get more information about lot coverage, which I know is perhaps still a question for a couple of board members. So just to review, in your memo, which is under tab 3, the two variances that have been requested of us are minimum rear yard, 30 feet is required, 20 feet is proposed for the additions would be a 10-foot variance, and minimum corner side yard, 20 feet is required, 15 feet is proposed to be a 5-foot variance. According to the appellant or their representative, they said that they did not need a maximum lot coverage variance, and they sent an updated site plan that is in your file. The proposal changed their plans to make the proposed deck smaller so that it would fit under 30% lot coverage. So I think from talking to a couple board members that they have questions about whether or not that updated plan does fit under the 30% lot coverage maximum. And then also there's the question, the board just needs to deliberate based on the information presented about uniqueness, practical difficulty, and the other variance standards. The case file is under tab 4. Normally I don't print them out for everyone, but I did this time so that you can look at what I believe is the updated site plan and statement of justification, et cetera. So yeah, I'll turn it over to you, James, and you can decide what to do from here, I guess.
Oh, let's back up for a second here. We're here only to deliberate on the record that we have. They submitted the updated site plan, right? It's in the record now. That's what you reviewed. When we left the hearing, we were in a posture where.
Is your mic on? Yes.
It is. It's just over here. Anybody hear me? Okay. My recollection is we were in a situation or in a posture where maybe we presumed that by the submission of a new site plan, the lot coverage issue was going to be resolved and there would not be a minimum lot coverage variance needed. Question becomes, when we get that document and it still places that issue in dispute or there's a question, do we give the applicant an opportunity to explain how it is that no lot coverage variance is required, or are they now stuck with it?
I
Because
guess
we
is
have
the
some
question.
questions regarding this site plan.
Is the question whether the board can reopen
Well, I know we can.
the case? Yeah.
I just want to be sure that's where we were.
Right, exactly. So where we left it, according to my recollection, is that we knew that the updated plans needed rear yard and corner side yard. And then we didn't have lot coverage calculation. And we were unsure whether it was over or under the 30% that's allowed and whether they would need a variance. So the applicants said that they would give us that tabulation, essentially. And the email that Mr. Hoffberger sent to us, which you only have the attachments, not the email itself, but can you open it? Says that they've decided to remove the existing deck and shorten the length of the proposed deck. And they updated, they attached an updated site plan, which is what you have. And they said that the total square footage of lot coverage is 29.9% of the lot.
That's not what your calculations say.
I mean, it's not my job to calculate it.
Yeah, right.
It's just a question that we asked, but I would hope that we would get, sorry. I would hope that we would get the calculation, since we asked for it last time, to verify the 29.9%, but I mean, you tell us how we have to proceed.
So wait a minute. We asked for the calculation. They
Well-
sent an updated site plan. It said, do the calculation, trust us.
Well, hold on, they have some email with calculations in it that I did not print out for you.
Okay.
So we can print that out. You have it printed
You can
out?
see you sitting there, so.
Yeah, I have it right here.
Okay.
29.9%.
I can run upstairs and print it out, or Mr. Hofberger, it looks like he has one copy that he can present to the board now to look at those calculations more
Yeah,
carefully.
why don't you come on up and do
Sure.
that?
Do you want to read it? Do you want me to spell it out into the record here?
Actually, you probably ought to go on the record.
Yeah, you should go on the record since you've spoken.
Okay.
Yeah.
Do you swear or affirm on the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank
State
you.
your name.
Chase Hofberger. So, okay, so the changes that were made to the original site plan is that the existing deck has been removed and the proposed deck has been shortened. The math here is that the total size of the lot, based on city plats, is 7875 square feet. The existing structure has two portions. One is 14 by 20, the other is 27 by 22 and a half. So when you combine those two, you get a total of 890.2 square feet, okay? There's an existing shed, it's 10 by 14, that's a total of 140 square feet. The applicant proposes an irregularly shaped addition to the structure. The square footage of that addition is easier to measure if the addition is split into two parts. One is 29 and a half, the other is 26.7. Or I'm sorry, one is 29 and a half by 26.7. The other is 22 and a half by 15. So that's a total of 1132 square feet. And then there's also this proposed deck that is 196 square feet. The removal of the deck, of the existing deck, removes 100 square feet from this whole math equation. So the total square footage of the lot coverage is going to be 2,358.2 square feet. And when you divide that into the size of the lot, as Mr. Marcosi might be doing right now, you get 29.9.
Lovely.
And that's the most math I've done in a while.
Could we keep that?
Yeah,
Please?
for sure.
Thank you.
Sorry, Jay.
Thank you for that addition. I think it might prove helpful. Okay, since you had the floor, anything else you want to add at this point?
I'm here to answer any questions.
Well, since we put you back on the record, and I know Mr. Berry wrote this memorandum, stating the legal justifications, but why don't you give us the 50-cent presentation on uniqueness?
Mr. Hofberger wrote the memo, so
Okay.
he can give us
Oh.
the presentation.
Thank you, Ms.
Good, I'm
Witt.
glad
You know
you gave him
that Mr. Barry doesn't quite put together this.
I don't know what he does. I'll take your word for it.
The property has some unique components concerning right-of-ways and easements. In particular, this has to do with the way that the property is perceived by the neighborhood, by people walking past. The most prominent one concerns the right-of-way on what would be the corner side yard setback. And that's because it's set up as a right-of-way originally, back in the 1950s. But there was never any sidewalk installed on this property, and the grass has grown up in such a way that it honestly very actually looks like Mr. Goldman's yard. And so whereas there is a certain distance from Mr. Goldman's existing structure to the edge of the property line. Anybody walking down the street would perceive that there's actually 5 feet more. So prohibiting him from being able to use that as part of the setback puts an unnecessary burden, unnecessary hardship on his ability to build out the property, to build out the structure.
What if the city decides to put a sidewalk there? Which they've done before.
That would be an unprecedented thing in this neighborhood where nothing has happened for more than 70 years. But certainly this would be a medium to discuss that or handle that. In the backyard, there's already an existing shed encroaching on the setback, and the proposed addition doesn't encroach on the setback any more than the existing shed does. So there's no effect to the neighbors.
Let's see. I recall asking Mr. Berry, but for the easement, you would be able to comply with the bulk regulations with regard to the corner side yard?
But for the easement,
Yes.
if that easement wasn't there, yeah.
And in the rear, what's in the rear again?
There's a shed in the rear. And there's a BG easement that runs through the back.
All right. So, but for that easement in the back, would you be able to comply with the bulk regulations in the rear yard?
We would need a variance for that.
And you find the existence of those two, your contention is the existence of those two conditions, make the property unique. So those are but-for conditions, but for the existence of those easements. You'd be able to comply with the bulk regulations to do what it is you want to do.
Well, certainly on the side yard, but no, the rear would still require a setback. The issue there is that there's an existing structure already there, so you're not moving in.
Yeah. Okay. Okay. Anything else? No?
No.
All right. Okay, thanks. So I guess it's up to us to deliberate now. So this question of the rear yard. There's an existing shed, okay. We like to keep it simple and make it so that if there are but-for conditions, like the easement for the corner side yard, you'd be able to comply with the bulk regulations. What do we do about the rear yard? So the easement on the corner makes it, the property unique for that variance. Does the one for the rear make that unique with respect to the rear yard? That's the question. Sure there's a simple answer to this?
I mean, I think the existing shed that's currently there is, I can understand the concern about saying that there's an existing structure already there, So we're actually 15 foot 10 in from our property line. Perceived, I understand the explanation of being perceived. It's an existing non-conforming shed.
The shed could be conforming as a permitted encroachment. So there are certain things that are allowed to be built in the setbacks, including sheds, sometimes porches or decks. So I haven't done the math to see if the existing shed is non-conforming or if it's actually conforming under the permitted encroachment section of the code.
So, but you just said decks might be something that could be constructed in the encroachment with permits.
Yeah, so decks can be constructed, what is it, up to 8 feet into the required yard. In this case, that doesn't help us on the side because the deck is in the back. For the rear yard, I would have to look at the plan again to see if that helps us. But I think that in the rear yard, it's more than 8 feet into the required yard. For the right, it would still need a variance because it's more than 8 feet into the required rear yard.
Thanks. So to clarify, right now, we're just trying to deliberate on the rear yard since we feel that the side yard issue has been resolved, or have we just felt like the side yard has demonstrated uniqueness?
That's, the latter is where I am.
Okay,
And the issue is what demonstrates uniqueness with regard to the rear yard.
mm-hmm.
Just sit back there. One's perception of the rear yard is also distorted by an easement. This time, I'm sorry, Mr. Hoffberger, I want to hear from you again. Again, reference to the memo, said one's perception of the rear yard setback is also distorted by an easement, this time for electrical wires that run northbound toward Hanson Avenue. So that's from the rear?
In the rear, right.
So what is the significance of let's see. So there's an easement for electrical wires.
The property essentially has 3 easements around it, on three of the sides.
I only see one easement identified on the site plan.
The right of ways for the sidewalk. Well, I guess those aren't easements, but there's
All right, that
2
makes
right of ways.
sense. All
Right.
The right of ways. All right, so we have the electrical easement that you're saying is at the rear yard. It goes from Bartle all the way through the other adjacent properties as well. Right? And then, so we have an existing shed that's partially falling inside that easement. And then our proposed deck is going 15 foot, I say our, but the proposed deck is going 15 foot 10 from the property line.
Mhm.
Okay, so there's the relief that you're asking for is right there for it's actually to the proposed deck. Okay.
To the right.
so,
I'm trying to correlate the site plan with the descriptions of the
Yeah.
requested reliefs. I'm just finding disconnect, which I found disconnect last time too.
Right.
so. How many feet is the edge of the deck to the property line on the rear yard?
15 feet, 10 inches.
See, on the site plan, it looks like 15 feet, 10 inches goes to the center of the easement. So is the red line the property line?
Red
or
line is the
green-
property line, the green line is the edge of the
Okay.
easement. So the easement covers,
Goes into the
It goes in-
property.
right, it
Okay,
goes into the
that's-
property.
I just wanted to make sure that I understood.
it's a 5-foot easement.
Does that help you, Liz, with regard to, I guess that's
mean-
the rear?
A little bit, it does.
It should probably speed it up if I didn't have to do the calculations myself.
I can tell you my issue. I don't know what else I need to know to figure this out. So,
In terms of what,
Well-
the standards or?
Well, one thing to think about too is that the proposed deck can encroach, as Ms. Witt was saying, it can encroach a certain amount into the setback. So the issue is actually where it encroaches to the house, which is less than, it's a few feet less than the 15 feet.
So what dimension is that? If we're actually excluding the proposed deck, you're asking for the relief from the property line to the proposed new construction, but there's no dimensions given on the site plan, and I'm trying to figure that out based off of what's described in front of me with that relief.
Right, well, the site plan has it at 20 feet here, so maybe that's not necessary.
So the existing
20 foot
structure is 20 feet, and then it is 14 plus 15 feet, 10 inches from the property line. Am I under, yeah.
The deck is 15 feet, 10 inches, the
Right.
proposed deck, and then the proposed new structure is 20 feet, 2 inches from the rear lot line.
But we're actually looking at the three-story structure is the one that,
The proposed new three-story
Proposed new
structure.
three-story structure.
Yeah.
is the one that needs the variance.
Well, they both do.
Okay.
Corner side, is that the corner side yard variance?
The proposed new three-story structure needs both a corner side variance. It is
And the rear
20
side.
feet setback. Wait, sorry, it's 15 feet setback and it's supposed to be 20. And it also needs a rear yard variance. The rear yard is supposed to be 30 feet. Both the deck and the proposed structure encroach on that 30-foot required rear yard.
So we need 10 feet from the structure, a variance of 10 feet, 10 feet of relief.
And so the thing that we're trying to determine is the uniqueness of the rear property that will justify the variance. I'm just trying to figure out the linchpin.
well, it's unique in my view with regard to the easement that doesn't have a current sidewalk that runs all the way back. My understanding is that's as we use in causation language in court, a but-for circumstance. But for that easement, we would be in a position to comply with the bulk yard regulations and would not need a corner side yard variance. So I'm looking for the condition that is the but-for condition
For the rear.
for the rear.
And so right now.
And just so I'm clear from your perspective, is the site plan, does that say everything that we need to be able to figure this out?
After
Or we still-
the description
Yeah.
of understanding that we have to, that the deck has opportunity to extend into the setback. So it's the 20-foot is what they're looking for right there, right? So I can understand that. It's just my question right now, for me to approve this relief, is there any uniqueness to this specific situation? We talked about the side yard, but now we're talking about the rear yard. The fact that there is an electrical easement there, but the electrical easement has, in my eyes, doesn't have any conflict to the location of the building itself. I'm trying to find something in that regard. If that makes sense.
Do you have to find uniqueness on all sides of the property, or is the property just determined to be unique?
Well, we can have, a unique feature, but it may not have anything to do with the variance that the
Sure.
party is seeking.
Okay.
And so,
There has to be a connection, right, between the uniqueness and the practical difficulty that's involved in developing the property.
Or
So-
for the time being, the unnecessary hardship.
Right. Well, we're using practical difficulty in this case because unnecessary hardship only applies
To uses.
to uses, which
Okay.
we're not doing here. So are we in deliberation phase at this point?
Yeah.
I think so.
I am deliberating.
Okay.
Yeah, yeah.
not as long as we keep hearing from the witness, but I did ask him to testify.
I think for the right of way, I'm more inclined to see a unique circumstance that gives way to the practical difficulty or necessary, whatever we're calling it. That would, that makes me comfortable allowing the corner side yard
Right.
variance.
Right.
The electrical easement for me is the one that gives me more
That's-
pause.
And so to refresh my memory, is there a reason they just can't make the 3-story structure smaller?
That's always the question.
Sure.
That's always the question, right? Like, why couldn't you build this within the setbacks? The
I'm
memo
looking at
is.
the memo.
The memo is before you,
Yeah.
and the testimony has been what it is. So if you don't find it there, then you don't find it there. Or if you do, then you do.
All right.
Indulge me for one more minute. Mr. Hoffberger,
Yes, sir.
coming back to the podium.
Bring him up too.
Got something to offer on this issue.
Yes, sir. This is Daniel Goldman,
Yeah, how are you?
the applicant.
Welcome back.
He would need to be sworn in if he's
Yeah,
going to talk.
being sworn in. So why couldn't the structure be built within the rear yard setback?
Do you,
Do we swear Mr. Goldman in?
Can we keep it sworn, or we got to swear him again?
Mr. Goldman has not been sworn.
Oh, he hasn't. I thought he got sworn in last time.
Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Affirm.
Thank you. Can you state your name?
Daniel Goldman.
Welcome, Mr. Goldman.
So, if you look at the plan, I think we're in an R1?
Oh, R1.
R1 zone. So in terms of, we already have the pre-existing addition in the rear, which was legally done under permits. So that really leaves us with, in the front, I think we have just 7 or 10 feet we could go out. And that space, that's not a very significant space. On the side with the Bartle, where the street side is, right now, if we don't get the variance on the side yard, that would mean that there's a chimney there, so that would be like, that's connecting to the furnace and everything, like we said last time. So that would be, we'd have to redo all the mechanical for that. In terms of the rear, that's where we're going. And then in terms of the neighboring side, we have 7 feet, so really there would be no space. And everybody is asking about the space, in terms of hardship, in terms of the religious needs. People can't travel a mile away from a hotel on a Saturday. There's no traveling, we can't drive, so we have older parents and we have siblings, so we need the space to have people, so that is a unique hardship. I don't know if that counts for anything.
Well,
So where else would we build if we wouldn't need a variance?
so I think the question that I needed refreshing on was not why you need the structure at all. Like, I understand that. It's why couldn't the 3-story structure be slightly smaller? So, for example, could it go in the amount of feet required to make it, I don't know exactly how it, but let's say
to there.
in the footprint of the existing 2-story structure? Because I think if we did that on the rear, they would not need a variance. My understand. I don't want to speak out of turn.
Yeah, so like
I'm in the.
Sure.
5 less feet
That's why you need it to be
on the
so
side and what,
as opposed to just-
10 less feet in the rear?
Yeah, I'm comfortable with the side. I understand that.
Yeah.
I think it's, what is the reason that the addition needs to extend 10 feet
Yeah.
into the rear?
Yeah, that's a good point.
I mean, do you want like the practical breakdown of the family size? I'm not sure what the
Well,
question
that
is.
doesn't.
I-
that
What
doesn't
we're
help.
getting at really is,
Yeah.
what would you be losing if you had to build within the setbacks as required? How
Just
would
the
that,
rear.
how would the less space be functionally different than what you're proposing today?
We wouldn't be able to fit the amount of people that related to into the house on a Saturday when people can't travel. I mean, we just wouldn't have that space.
Okay,
Yeah.
okay.
Is that the floor plan for the addition that you're looking at, or?
That's what I understand it to be.
Okay.
So the principal hardship here is the inability to to have your family together on the Sabbath, essentially? Okay.
Yeah, we just had that, my wife's family was in, and we couldn't eat with my in-laws, they couldn't eat with us, it was just like,
Okay.
it's just not practical.
And because the addition doesn't encroach on the existing setback due to the shed, I think it's somewhat de minimis.
Right. Point taken.
And that information puts us where?
I don't know. The fact that there's an existing shed already in the electrical easement, already in the setback, to me, helps me see more uniqueness, perhaps, in the more uniqueness in the property. So, I don't know.
Did you all place the shed there? I'm sorry, I'm obviously getting more testimony, I'm not deliberating.
Yeah, we did.
You did?
We had a permit to do it, yeah. It was about done, I think, 17 years ago.
Well, I'm not sure that helps your uniqueness argument with, if you put the shed there, and we're going to consider that, the fact that a structure is already encroaching. Are we then talking about a self-created hardship?
I mean,
Yeah.
the shed itself doesn't cause the hardship, so it's not
Right.
self.
And the size, the place, meaning if we didn't have the legal addition, which is in the proper place, then we would actually be able to build out on both sides. So the legal structure is what's creating the hardship, not the shed, which is at question.
My point was to assert that it enhances the uniqueness argument to say that there's a shed that's already sitting there if you put the shed there. I don't think that helps the uniqueness argument. That's my point.
I think the challenge is that for the new 3-story structure, the side yard, I understand, we're good. It's when we're looking at the rear yard, and when I asked what would happen if the addition was, we'll just use the word shorter since we're going front to back. If the addition was 10 feet shorter, I understand that that does limit the square footage that you have for the addition. But in terms of looking at a floor plan, what that means is it's just smaller rooms. It doesn't mean that you can't put people there. So I'm not the number of people can't be the reason, if that makes sense. Because the number of people is sort of irrelevant because you can gather lots of people in a smaller space. So that's the challenge that I'm having right now. Because right now it's a desire to have a certain square footage, and we have to figure out another reason besides number of people, because that does not meet the threshold, in my opinion.
And I agree with you in that regard. I mean, you're doing a very large addition here. And I have nothing wrong with the large addition, but it's just, it's the fact that you're asking for relief to have a certain amount of people come into the house. Okay, and I think that's my biggest problem, is that's not a practical difficulty that we can approve. If that were the situation, everybody would have larger houses if they could afford to do additions. But I'm just struggling to see that at this point.
So can I just say something, that when we get together, we're required to have 3 meals on a Sabbath. So in order, my wife has 8 siblings, I have 4 siblings, we both have parents. So we're not just standing there, in a social gathering. We're actually required tables and chairs and kids and space for people, as opposed to just standing and, at a buffet.
Yeah.
Hang on a second. I have a question for you. We went over last week mechanism whereby reasonable accommodation is something that we have available to us.
Religion
Is
is
there such a
not,
thing as religious accommodation?
I mean, that could be an
In the context of
interesting,
the zoning
that could be an interesting research project, but as far as I know, no. And, I mean, we talked about that under the ADA.
Sure.
Obviously, religion and
ADA.
disability are two different things.
Right.
So.
I just wanted to put that on the
So,
record.
so no, I mean, I think, and I did bring this up last time as well, we get a lot of variance applications disproportionately from this
West
neighborhood,
Baltimore.
from this part of town for similar reasons. And something that I have brought up with the city council member for this district is that the restrictions seem to be too restrictive for the people who live in this neighborhood.
Sure.
And that it is interfering with their ability to use their homes in the way that they want to. And that is absolutely something that can be addressed legislatively. Unfortunately, this neighborhood is zoned the most restrictive possible zoning district, R1, which is the largest required yards, the largest required lot size. And so maybe that doesn't fit the needs of the people who live in this neighborhood. But that is not something that the board can take into account on an individual basis. It's more of a policy decision that needs to be made by city council. And it's something that I have raised with them. So
Okay.
that being said, obviously the board can still decide whether this particular application qualifies for a variance or two variances.
Now, we continue to come up against issues of practical living in various neighborhoods and the way, people live in 2024. That butts up against the code, which also butts up against the need to retain citizens and residents and keep them here and allow them to do what they need to do to stay. But the difficulty is almost legislating from, because they clearly can't work or won't work fast enough or take it up and deal with it the appropriate way, which is legislatively. So we're being asked to effectively, de facto legislate, as a board, which creates a whole cacophony of situations where lots of people want bigger places, right? For many reasons, religious, familial, tradition, but it keeps coming back to uniqueness of the property and how that relates to the variance that's being requested. So I think we're without the ability to extend that, to stretch that, to do the legislative things that ought to be done legislatively. So, based on the record before us, I see uniqueness, and we could follow all the, I think it meets the standard for a variance for the corner side yard. But with regard to the rear, I think we're not there, particularly given the additional testimony we've gotten as to the basis for it and the reason. There's no additional, bases that go to the uniqueness of the property and its relationship to the rear yard. So, for what it's worth, that'd be a yes as to the variance for the corner side yard, but a no as to the rear yard.
And I just want to state for the record, so that it comes from the board, there's a council person that represents District 5 that through a very simple legislative process could make it so that many people from your community that are coming and asking for the same thing week after week. And I don't know what the barrier to that legislative fix is, but this community is very organized, they're very unified, and my hope is that the burden of coming here, that the burden of having construction delayed from the cost that this inevitably is incurring to have this delayed, that I am at a loss as to why your council person does not take this seriously. And that is not your fault, But there is a path here. And I hope you understand that I am 100% sympathetic. This is a pretty straightforward renovation. I understand how it visually doesn't necessarily impact your neighbors and your neighbors are supportive. But we have to interpret the law. And right now the law is not allowing the latitude right now for the rear yard. And I will just also add the legislative process for something like an ordinance to eliminate bulk regulations, even something specific as R1, is actually not that long. You can introduce a bill next Monday and potentially have it done in 6 weeks.
Yep.
So we're going to have to make our decision today, but I would encourage you to make a phone call after you walk out of this room and see if we can start the 6-week clock. And it would be a huge victory for all of the members of your community to be able to have similar latitude that other residential districts have. And so I'm sympathetic. And I hope that this lights a fire for the council person of District 5.
Well said. I guess we have to take a vote.
Yeah.
Yeah. Again, as to the corner side yard variance, I mean, yes. For the reasons, the uniqueness, and I believe it meets all of the elements of required findings that we're required to make for a variance. As to rear yard, can't find uniqueness, so I'm a no as to that.
I'm a yes to the side, I'm a no to the rear.
I'm also a yes to the side and no to the rear yard setback variance.
I'm in agreement with those same votes, yes to the side, no to the rear.
I'm the same.
Okay, thank you.
Thank you.
Thank you.
Good luck to you guys.
Well, that took longer than I expected. So, are we ready to move on to the zoning docket? So in your notes, you have a proposed order of cases there, just on that first page under tab 3, because there's some significant opposition to the very first case. Generally speaking, the board likes to take the cases more or less in order of ease, doing the quick ones first and saving the more complicated ones to the end. So I've made a proposed order there. Do you see them? Okay. All right, so I will get started and get my introduction. Good afternoon. Welcome to the 1 p.m. docket for the BMZA. My name's Becky Witt, and I'm the executive director to the BMZA. From left to right, we have Victor Clark, Leland Shelton, James Fields, who's the chair, David Marcosi, and Liz Cornish. To my left is Jim Ullman, who's the assistant counsel to the board. Please silence your cell phones. If you need to have a conversation with someone, please do so out in the lobby. When it's your turn to speak, please identify yourself and spell your name for the court reporter who's sitting opposite me, and be sworn in to testify. If you haven't already signed in on the sign-in sheet in front of Eric Tiso right over here on this table, please do so. The board will probably vote on your case today, but that does not make our decision final. We have to issue our decision in writing in a document called the resolution, which is a process that takes several weeks, up to 30 days. It needs to be drafted and reviewed, and then we will send them to you via email when they're ready. If you're unhappy with the outcome of your case, you can request reconsideration of the board's decision within 10 business days of the issuance of the resolution, and you also have the right to appeal the board's decision to the circuit court within 30 calendar days of the issuance of the resolution. If the board approves your appeal today, you have 1 year from the date of your resolution to either get your use permit in the case of a conditional use appeal, or to pull your construction permit and begin substantial construction in the case of a variance. If you need more time, you have to request an extension. Please submit your extension request before the year lapses, and the board will consider your request during its general meeting. And I will turn it over to the chair.
Becky, let's go back to look at this docket real quick with regard to the 3 o'clock docket.
Oh, yeah. Did you want to talk about that now?
Let's do that now. So
Okay.
have that sort of in the crawl.
Okay. So do you want me to give, or have the people come up and I can give a little background on what's been going on?
I would appreciate that.
Sure, if you want to call it, I guess, first, and then I'll give the background.
Okay, case number 2024-080 and 2024-132 through 2024-153, 3220 Southern Avenue. To appeal the issuance of use permit 2023-55233 and use permit 2023-55234 and all the way up through a lot.
Sure, so I'll give the background here. Essentially, due to no fault of the appellants in this case, these appeals were not properly filed by the zoning administrator's office. It took some weeks for them to be filed. Essentially, okay, I'll start from the beginning. So these are appeals against the issuance of, I believe it's 23 or 24 use permits, separate ones, that the appellants believe should basically have been all considered as one use permit. And so they filed against all of those use permits, and they were not put into the system correctly by zoning administration, which is the office that accepts all of our appeals. And so finally they were filed, but they were not paid for appropriately. And so it has been a saga of months to try to get zoning administration to collect the correct fee for these appeals. And finally that happened last week, and the community, who is the appellant in this case, which is very important to know, said, we need a few more days to come up with $2,300 to pay for this fee that is all of a sudden being collected by zoning administration.
And when was this first filed?
Oh, I don't have it offhand. I think it's way back in April. Was
March
that
24th.
March?
Yeah.
March 24th, 2020.
I'm sorry, Chairman Fields, and good afternoon, by the way. Jamar Brown of Rosenberg, Martin, Greenberg. I represent the appellee in this case, Recovery 180 LLC. But to answer your question, the original appeal was filed on March 8th, 2024.
Okay, thank you.
So, anyway, it's been many months of trying to get these appeals correctly entered into the system. They asked the appellant, then said, I think that the call from zoning administration was made on Wednesday of last week. After, like I said, a long time, they said, we can't file it, or we can't bring the check by Friday, which is what would have been required to happen because Monday was a holiday. And they asked for a postponement, and I granted the postponement. And that's where we are.
Okay, and so you granted an administrative postponement.
I did.
And just for the record, what are the tenets of an administrative postponement? There's a rule
Sure.
that allows you to do that.
There is a rule in the board's rules that says that if the appellant requests a postponement in writing 48 hours ahead of the hearing, then it's up to the executive director to decide whether or not to grant the postponement.
Okay. And you did that?
I did.
And that was communicated to everybody?
It was.
Okay. If one wanted to challenge an administrative ruling, like the grant of a postponement, what is the mechanism to do that?
It's a good question. Our rules that were adopted back in 2016, I'm not sure they have a system in place to challenge an administrative postponement like this. Oh, Jim, do you have any thoughts on this?
I would just say that this being an administrative board,
Yeah.
what I would advise is you can hear Mr. Brown's arguments. It will be part of the record. You can take note of it, but then to also hold a hearing on the merits of this case in the future, which will all be part of the same record. And I think that is the best way to move forward with this mess of a case.
We're all about protecting the record here. So with the understanding that you've granted administrative postponement.
And the
The
appellant
appellant
is
is not
not
here.
here. Yes.
And I do understand that Mr. Brown, on behalf of his client, has raised issues associated with that. So we'll give you an opportunity to go ahead and put that on the record, Mr. Brown.
Thank you, Chairman Fields, and I realize for the reasons that you indicated that the relief that I would be asking for is not going to happen today, primarily because Mr. McCann, who represents the appellant in these cases, is not present. But I do think it's important to make a record here.
That's fair.
And we've talked a lot this morning about the BMZA rules.
Is your mic on, sir?
I think it is now.
Thanks.
Okay, thank you. We've spoken a lot this morning about the BMZA rules in the context of granting an administrative postponement. Those rules, I think, apply with equal force as it relates to this fee issue, this fee issue that we're raising, and we will continue to raise in written papers following today. And let me just give some brief history about this case. So our client received 23 use and occupancy permits for these 23 individual residential care facilities. Pursuant to the BMZA rules, there was a negative appeal filed as to each one of those use and occupancy permits. That negative appeal was filed back on March 8th, 2024. Under BMZA Rule D2, it states clearly that appellants shall have 10 working days from the date appellant receives a letter from the board to perfect the negative appeal by submitting all requested documents and information. And then it goes on to say negative appeals not perfected in the required time shall be dismissed at the next ensuing meeting of the board. Shall be dismissed. The board sent notice to the appellants to perfect this appeal on March 24, 2024. That means that the appellants had until April 3rd, 2024 to perfect the appeal, which is to pay the filing fee as the BMZA rules make clear.
Hang on one second, Mr. Brown. So saying the board sent the letter on March 24th, is that the letter from the executive director to the appellant saying you have to pay the fee?
Well,
Or-
yeah, you have to submit any evidence and finish
Got it. And at that
filing your
time,
application.
zoning administrator was still of the view that they didn't have to pay.
MIA would be the more accurate description.
Okay,
Yeah, there wasn't like a view presented, there was just a silence.
got it.
It seems like we could go over these things at the rescheduled hearing, but I'll let you.
We could.
Well, and I won't belabor this, but my point is, we're here today on a postponement request. And my point is that there is no discretion given to the board on whether or not a dismissal is appropriate when an appellant doesn't perfect the appeal by the required timeframe as set forth in the BMZA's own rules. And so the reason why I wrote Ms. Witt asking for an opportunity to be heard today is because a postponement request cannot cure what should have been dismissed many, many months ago, because the appellant in this case hasn't paid the fee required for this board to even have jurisdiction to hear this appeal. And the idea that this is somehow the fault of the zoning administrator when the appellants knew that the entire premise of their appeal in the first instance was challenging each and every one of these appeals, any reliance that was placed on the zoning administrator was entirely misplaced. Because based on the BMZA's own rules, a fee needed to be paid for each one of these appeals. Our client has been willing and ready to proceed with this case. They've been issued use and occupancy permits, and they're ready to establish these facilities. And the fact that we're here all these many months later, we're talking about 6 months later, and the appeal fee still has not yet been paid, under operation of the BMZA's rules, this matter should have been dismissed. And it's unfair to our client in this case to have to continue to experience the delay and all of the costs that's associated with it. So again, I realize the board is not going to be able to grant me any relief today or our client any relief today, but I do think it's important that this issue be known. And quite frankly, the idea that the executive director would be counseling the attorney for the appellant to belatedly pay this fee when the cases should have already dismissed, I find incredibly problematic, and it diminishes our client's faith that this proceeding is going to be carried out fairly and impartially. And so those are the comments that I wanted to make, Chairman Fields. I will, as I said, we will brief this fully in a motion to dismiss that will be filed before the board.
Okay. Thank you, Mr. Brown. So, for the record, the matter is postponed presently, and it will be rescheduled at some point. And you'll communicate with the parties with regard to that?
Yep, sounds
reschedule?
great.
Okay. Thank you, Mr. Brown. All right. Now I don't have to worry about the second docket. Mr. Brown, I should just say for the record, obviously your argument is preserved for the rescheduled hearing and
Okay. And
will be taken up because you made a formal motion.
We'll work in good faith with Ms. Witt and Mr. McCann. I mean, if there's any way we could at least be heard preliminarily on our motion to dismiss prior to October, we would welcome that opportunity to get this matter resolved as quickly as possible.
We'll consider that. It is September, so it's what, next month, right? Yeah, okay.
All right, thank you.
Sir. All right, Ms. Witt, you have the order?
Yes, the order is under tab 3, just that first page, says proposed order of cases. It's in a box there.
All right.
Do you see it? Tab 3.
No. On the general meeting agenda. On this first page. Oh, there you go.
Oh. I'm looking at the,
It's the one in your binder.
one in the binder.
Order, please.
Page before that.
Right here.
Okay. I'm looking at some, they're looking like ordinances to me, cases, just case numbers. Okay, case number 2024-172. Let me get that one. 2615 Quantico Avenue, Right Way LLC. Good afternoon. Welcome back. This is a request to continue the use of the property as a multifamily dwelling with 2 dwelling units requiring confirmation of non-conforming density, correct?
Yes, sir.
All right. Let's get the, with the sword, please.
Do you swear or affirm under penalty of perjury that the answers that you give in the statement that you give are the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Can you state your name?
Berto Tuis.
Okay.
B as in boy, E-R, T as in Tom, A-U-T, and the last name is Tuis, T-C-H-U-I-S-E.
All right, I'll hear from staff and planning.
All right, the request is to continue to use the property as multifamily dwelling with 2 dwelling units. The property is zoned R6, and I believe these properties are part of the same kind of block of properties that this same developer is redeveloping. They were originally created as 2 dwelling unit row houses, and we have a use and occupancy permit from 1969 showing that they were approved for 2 dwelling units. Hasn't been reduced since then.
Hey, good afternoon, Eric Tiso. Last name is Tiso, Baltimore City Department of Planning. Yes, this is indeed one of several renovating these vacant properties in the same block. And on hearing from my colleague Carrie Nye from the neighborhood, she just recommends the applicant stay in contact with the Green Spring community to consider continuing that positive contribution to the neighborhood, and we recommend approval.
Thanks so much. Okay, good afternoon.
Mr. Field, good afternoon.
Okay.
Members of the board.
So obviously, our records reference two dwelling units, as far back as 1960, and there's been no change to that. Do you intend to use the property in any other manner other than two dwelling units going forward?
As is.
Okay. Anything else you'd like to add in support of the record?
I just wanted to say that, I've been here a few times, and, I wanted to say thank you for your time. Thank you for, Ms. Wade, Ms. Jane, for being patient with me through all this thing. And, with your help, as far as, making sure that we completely change that neighborhood. There's an effort in place of also renovating the next block over, so you probably hear from me also very soon. I just want to say thanks, to all of you and to the whole, community for being so supportive.
Okay. All right. Well, thank you for being here again. In connection with 2615 Quantico Avenue, the applicant or appellant seeks to continue to use the property as a multifamily dwelling with two dwelling units. Our records indicate that this has been two dwelling units per use and occupancy certificate that was issued on December 15th, 1969. There being no change to that use going forward, I'm a yes for this confirmation of non-conforming use.
I'm also a yes.
Density.
I vote yes.
Also, yes.
Also, yes.
Thank you. Thank you.
Thank you, Mr.
See you
Field.
back.
Okay, thank you.
Okay, case number 2024-185, 2628 Loyola Southway, GSP Tracking LLC.
All right, yeah.
Okay, this is a request to continue use of the property as a multifamily dwelling with two dwelling units requiring confirmation of non-conforming density. All right, we have someone new. Your name?
Lino Rasuri.
Okay, let's get this gentleman sworn.
Do you swear or affirm under the penalty of perjury that the answers they give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Can you spell your name? I know you should state it.
Lino, Lino, Rasuri, Razuri.
All right, I'll hear from staff and planning.
This is a request, like the previous one, to continue use of the property as a multifamily dwelling with two dwelling units requiring confirmation of nonconforming density. The property received approval for two dwelling units on August 8th, 1941, and we have no record of it being reduced since then.
And we concur and have no objection.
Very well. Anything you'd like to add to the record?
No, sir, thank you for all your help. And
You intend to utilize this property as a two dwelling unit property
yes, I
going
do.
forward? All right. Okay, any questions from the board?
No? I'm so happy to see you guys on Quantico, on the 2600 block of Quantico.
Thank you.
Good luck.
Thank you very much.
Okay, that being said, again, we're here on, for 2628 Loyola Southway to confirm non-conforming density for two dwelling units. Records reflect that this property has been authorized two dwelling units as far back as August of 1941. The appellant intends to continue to utilize the property as two dwelling units. So I'm a yes for this application.
I'm also a yes.
I'm a yes.
Also, yes.
Also, yes.
All right, thank you so much.
Thank you very
Good
much.
luck to
thank you very much.
Take care. Ms. Wade,
Thank you.
have a wonderful day.
Take care.
Thank you.
Okay, case number 2024-129, 3742 Tudor Arms Avenue. Mark Warheim. I'm sorry, Ricardo Sanchez, my apologies. Looking at the wrong one. This is a request to construct two-story rear addition with a basement requiring a variance to bulk regulations. Good to see you back. Welcome back. I think we've gotten our ducks in a row. These guys have been sworn previously. Do we need to re-swear them?
Yeah, I think so.
Go ahead and swear
It was a
me in.
different day.
Raise your right hand. Do you swear or affirm under the penalty of perjury that the answers that you give in the statement say the truth, the whole truth, and nothing but the truth? You're Mr. Sanchez, right? Your name, sir?
BANOS, James?
Here from staff and planning.
All right, so the request is for maximum lot coverage variance. 45% is allowed, 74% is proposed to be a variance of 29%. We partially heard this case on August 20th, and the appellants raised a question about reasonable accommodation under the ADA. So we got some advice from the law department about how to accommodate that, and asked for a little bit more information about the disability of the resident and how this proposed addition would accommodate that person with the disability. So I will just kind of summarize the information that they gave us. It should also be in your packets if you want to take a closer look. But the proposed addition would add a half bath and a washer and dryer on the first floor and an additional full bedroom on the second floor. And they wrote that the extra bathrooms are necessary for the resident who uses a wheelchair and is unable to go up and down stairs without a chairlift. So she needs a bathroom access on each floor, as well as access to the washer and dryer, which is in the basement, which is not accessible by chairlift. I hope I'm summarizing that correctly, and you can correct me if I've gotten anything wrong. The zoning code itself has a provision on reasonable accommodation, which says that if an accommodation is reasonable, necessary, and not a fundamental alteration, it says alternation, but that's not correct, alteration of the zoning code, the board has the ability to grant and basically an exception. It's not a variance. We're not going through the variance standards. We're going through the ADA standards. So down at the bottom, it says we have to evaluate the request by determining if the person who will live in the dwelling has a disability, if the accommodation is necessary, if it's reasonable, and if it does not fundamentally alter the zoning code or create an undue financial or administrative burden on the city. And I think that is it. I don't think Mr. Tiso has comments on this.
Okay, so welcome back. I'm glad we didn't have to send you all somewhere else to another agency to be heard. But we do have to, again, on the record, make these findings with regard to the reasonable accommodation. So again, with regard to the person who will live in the dwelling who has a disability, that is who, again?
It's my mother-in-law.
Your mother.
She has a rod in her back and two replaced knees.
Make sure you guys turn your mic on.
Apologies. Yes.
Okay.
And is currently requiring to use a walker now.
Okay.
She was here last time.
She was here last time, correct.
And the accommodation which you're seeking is necessary to accommodate her limitations.
Correct. Regarding the presentation, it's not a full bathroom. It's a full bedroom. It's a full bathroom on the second floor.
Okay.
The bedroom's already existing.
The bedroom's already there.
Okay.
It's just to add a bathroom,
And a bathroom on the second floor.
Correct.
Full bath.
Yes.
correct, for that room. So she'll have her own bathroom,
Okay.
which is accessible by the stair lift because the stairs are wide enough. Getting down into the basement, there's not enough clearance to get her be able to down into the basement.
Not at all.
Okay.
I barely fit down the stairs.
All right. And accommodation is reasonable. This phrase, the accommodation does not fundamentally alter the zoning code or create an undue financial or administrative burden on the city. I don't see that it does that. Do you see any, what it is you're seeking to do that would not create any additional costs on anybody other than the applicant? Is that correct?
Correct.
Okay. All right. And, I mean, you're not doing construction all over the house to accommodate, you're accommodating this individual in the spaces that she's likely to use, is that correct? Okay. All right, any questions for the applicants?
No.
All right, anything else you'd like to add?
Thank you for seeing us for the second time, and thank you for everybody's assistance in helping us get here.
Okay, got it. All right, thanks so much. Go ahead and deliberate on this. So we're here for case number 2024-129, 3742 Tudor Arms. We heard a fair amount of testimony previously on this case, and we needed to really get the understanding of what it is, what authority the board had, and under what standard it could consider reasonable accommodation under ADA. The applicant has presented testimony of a family member living in the home, his mother-in-law indicated, who has some physical limitations. He described them as, various surgical implants and things that otherwise create. She utilizes a walker to ambulate, move around. So there are some adjustments to the house that they needed to make to allow her to live there with that disability. So we have identified that, and they've certainly satisfied the requirement of identifying, who will live there, who has a disability, and also that the accommodation, which is the full bath on the second floor, the half bath with a washer and dryer on the first floor, those accommodations are necessary so that she'd be able to utilize them and be able to live in the home. Those appear to be reasonable to me. They've not gone out of their way to seek alterations of the house that are above and beyond what would be reasonable and what is needed and necessary for to accommodate the disability. And there's no evidence in the record that the accommodation fundamentally alters the zoning code or creates an undue financial or administrative burden on the city. So for those reasons, I'm a yes as to the reasonable accommodation request for this application.
Also, yes.
Also, yes.
Also, yes.
I vote yes.
Thank you.
All right, good luck to you.
Thanks, guys.
Thank you.
Thank you for everybody's help.
Case number 2024-162, 482 South Bedlow Street. Mr. Hurdle, is he here? I didn't see him.
He had a conflicting hearing in district court, so we might need to call him
Oh,
later.
okay, we'll put that aside then. Case number 2024-063, 3361 Beach Avenue, Nicolette Smith. Good afternoon. Go ahead and turn that mic on if you wouldn't mind. Making sure it's green.
Okay.
And are you Ms. Smith?
Yes, I am.
All right, this is a request to construct a sunroom in the rear of the premises requiring variances to bulk regulations. Is that correct?
Yes.
All right. Let's get Ms. Smith sworn, please.
You swear or affirm under the penalty of perjury that the answers that you give the truth, the truth, and nothing but the truth.
I do.
We'll hear from staff and planning.
Planning does not have a report on this one. From us, 2 variances are needed here to construct a sunroom addition. Minimum rear yard, 20 feet is required, 14 feet is proposed to be a 6-foot variance. Maximum lot coverage, 50% is allowed. 86% is proposed to be a 36% variance requested. And the board, we already went through kind of an in-depth uniqueness and practical difficulty analysis today. We'll have a couple more coming up, but that's what the board needs to decide with respect to this request.
Okay. Let's hear about we don't have a report from Mr. No. Okay.
Sure. So, so my backyard is on the left is, I believe, it's a dwelling that used to be a grocery store, I believe, is what I was told. And it covers all the way to the left. So the house next to me covers the entire lot except for the last 4 or 5 feet. I just say that as to point out that this doesn't really won't interfere at all with my next door neighbor. My yard was built up, I believe, by an architect before I moved in, and they cemented the entire backyard. It's all, there is no actual yard to speak of. The reason I wanted to extend the deck and build in a sunroom is just to use the yard. It is white asphalt. I can't grow anything back there. I don't really have a yard to speak of. So it's just to utilize that space where I haven't been able to.
Okay, so you're asking for some variances to allow you to build this sunroom.
Yes, sir.
So what you were able to hear prior to your case being called is a bit of what we have to do is make findings of fact with regard to variance standard. And the first finding we have to make is about uniqueness of the property.
Sure.
So I'm pulling up your application, but go ahead and tell us about the uniqueness as you see it of this property entitlement.
The uniqueness that I see it is that the backyard is built up and totally concrete, unlike all the other yards in my neighborhood where they can actually use their yard. So I understand I have a yard, but I'm not able to use it in a traditional sense. It's just a slab of concrete. So that's why I wanted the variance, is to build out, just extend my deck further than it is and put a roof on it so I'm actually able to use it. It's just too hot. It's blinding, out there. I mean, that's really the reason. It's just that I can't use the yard how it is now. And it is unique in that my neighbors do not have that same area built up in that way. I didn't do it. I'm not sure exactly why it was concreted all over. I'm guessing it had something to do with keeping it from flooding. I really don't know. But my yard is just unique in that way.
Okay. How long have you lived there?
I have lived there 4 years in October.
Okay. And that was a condition of the house when you purchased it?
Yes, it was.
Pull up the photos.
Tell me more about this flooding issue.
I'm guessing. I mean, I don't have a flooding issue, but I'm guessing that that's why I was told that by the gentleman I bought the house from that the basement was dug out 2 additional feet before he ever moved into the residence because there was flooding in the area. And I think that that's also why it was concreted as well. The whole thing was concreted and kind of built up to a ledge. There's steps up to get into my backyard that are not like my neighbors either. So it's not quite at the same level as my neighbors in the same area. So I am guessing on the flooding.
Did you have any photo? I see one photo that is uploaded to your application, but that's not of the concrete. That is
No.
of the building.
That's just pointing out the neighbor's house next to me and how it extends all the way out. I'm sure I have a picture of it, but
The photograph that you have the arrow pointing to the red brick,
yes.
is that's your house?
So the red brick is my neighbor, just showing how the building on doesn't interfere at all with them because their house totally extends. They couldn't see if I built out, 30 feet.
I will simply say that it would be helpful to have photos of the property that you're looking to build on. in your application.
Sure.
I mean, we can pull up.
I think,
Not really.
No.
What we can't see is that elevation that she's describing.
Yeah, I also want to learn more about the topography.
Right, that's the point. You say it's concrete, so take your word for it, but we know there's more evidence about what it looks like and how it's made, and but that's what we don't see
okay.
in front of us. And you have a lot of. Is that the property?
This is the property here.
Oh, yeah.
You can kind of see the steps.
Yeah, I can't see
You can't
anything
the
from the,
yard.
to the yard. The bushes and the growth right there by the telephone pole, looking into the back.
I think you're headed here,
That's
Chairman
all right.
Fields, but I think you're headed here, but I'll just state.
Yeah.
Um,
Yeah, we need more.
One of the things that we need to find is uniqueness. We cannot see the uniqueness that you are presenting because we don't have any photographs, we don't have any topographic maps to understand why your house is unique to all the others requiring the variance. Because I think if we could see that, we could better understand why, because the question that I would have, regardless of the photo, is a concrete yard is not unique in terms of what could allow for a variance, because in reality, it's your property, you can get rid of the concrete and do whatever you want with it. If there is something that you're demonstrating that is unique about the thing and that you cannot get rid of it, and that the only way to use your property is to have an addition, that could potentially demonstrate uniqueness. But right now, we just don't have all the information that we need. And so I am unable to make a decision today.
Yeah, your suggestion about, you're guessing about flooding possibly, maybe as a reason why the concrete's there. Any other information you might have that would inform us of, that in addition, in order for you to utilize your yard may be helpful as opposed to, as she said, breaking it up or any number of other things that maybe one could do.
What would you consider to be an expert to know that?
I'm sorry?
So I'm guessing that to be the case. Would
Well, you're
I
guessing-
ask a contractor to?
Well, if you're guessing, we would be double guessing because you're the
Sure.
owner. You're in the best position to find that out.
Okay.
So,
Oh, I'm asking if I got a contractor or somebody to look at the property to write an informed, I don't know,
that's
opinion
possible.
on the property?
That's
Okay.
possible. The person
Okay.
who you bought it from, maybe could get some more information.
He's
or-
in Sweden. I don't know where he.
I don't know
So I
what to tell you.
think, I think the key here is that we cannot tell you what you need to do. All we can say is that we don't have enough information today
Yeah.
to make a favorable ruling. So if we were to vote today, my vote would be not to grant the variance.
Okay.
But we cannot tell you how to go pursue.
But what we can do is offer you a postponement in order to give you time to gather some additional information, supporting information about the property and reviewing the uniqueness standards, to be able to present some additional information to us so we can consider it. So that's up to you. We'll give you that time to gather some more information, talk to whomever you need to talk to.
Okay.
To get something that would help inform us that going through the standards of variance, that we can consider that information and perhaps you're entitled to one. And when you do that, and when you're ready to come back, you can contact Ms. Witt's office and let them know you're ready to come back.
Okay.
And it will schedule you again, and we'll hear your matter. Because we don't want to rule, because if we rule and it's negative,
Sure.
you have to wait a year. So, would you like to take advantage of a postponement?
Yes.
Okay, very
Thank
well. Board in agreement with that?
I'm fine.
Yes.
All right.
Yeah.
Great, we'll do that, and just let the office know when you're ready to come back, and we'll hear your application.
Okay. Thank you, Mr.
Thank you,
Fields.
ma'am. Case number 2024-124, 322 South Wolf Street, Paula Richardson. Good afternoon, are you Ms. Richardson?
No, I'm the owner. My name's
Okay.
Amani, would be.
All right, but this is a request to use this property as a multifamily dwelling with 2 dwelling units requiring variances to bulk regulations, correct?
Yes.
You Get the witness sworn, please.
Do you swear or affirm under the penalty of perjury that the answers that you give in the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do, yes.
Can you state and spell your full name?
Amani Woodby, and it's spelled Amoni, last name Woodby.
Okay, hear from staff and planning.
All right, this one is a little quirky. So the variances that are needed for 2 dwelling units at this location, minimum lot area, 1,500 square feet is required. 1,275 square feet exists, so it'd be a variance of 225 square feet. Off-street parking, 1 space required to add 1 dwelling unit, 0 is proposed, so it'd be a variance of 1 off-street parking space. The last authorized use that we have in our files for this is from all the way back in 1966, and it's for commercial use on the first floor, beauty shop, and a dwelling unit on the second floor. We don't have any intervening use permits filed. However, it's unclear when this beauty shop use ended. It looks like it probably ended at some point, in which case, 2 years after the beauty shop use has been discontinued, it would have been abandoned and lost. So the board in the past has approved, not as a residential conversion, in cases where there was some sort of historic commercial use on the first floor and a dwelling unit above, that the property owner could fill in that formerly commercial space with a dwelling unit. Just because, and the argument being that it's difficult to recombine those two back into 1 dwelling unit. In this case, it looks like it already has been recombined into 1 dwelling unit, and so we need to find out more about how this property has been recently used as opposed to all the way back in 1966. So if it has been used as a single-family dwelling, then would that be a residential conversion then to convert it into 2? So that there's a bit of a quirk to this case, and I'll let planning make their report.
Sure, so to follow that, whenever there's a question of fact of whether that commercial use now non-conforming exists is up to the board, of course, to determine. In the case that it is, or the board finds that it is still there in an active non-conforming use, then we would encourage approval of a dwelling unit in its place that would extinguish that non-conforming commercial use, and we'd rather trade the extra density for that non-conformity. A lot area variance of about 15% would be required, and only 1 parking space would be required for the new unit, but the property's landlocked, so they're not able to provide it, so we would encourage approval of variance for that, and so we recommend approval.
Thank you, Mr. Tizzo. So, ma'am, what can you tell us about the use, more recent use of this property, particularly the commercial space?
Yeah, when I purchased the property, it was already purchased with the 2 units, and so
Purchased when?
I purchased it in January 2022.
January 2022?
Yes.
And you purchased it as a 2 dwelling?
It was already, yes. It was already.
So separately, is it separately metered?
Yes.
Did you see any sign of the commercial use?
It just looks like a regular, just space down there. It could be commercial, just a small room.
Well,
Does it look like an apartment or does it look
yeah, I
like
was
an
asking,
empty
does it look like a
Yeah,
dwelling
more-
unit or a space?
Yeah, more so because it had like a kitchen. It has a kitchen in there and a bathroom. So, I mean, you can use it depends on how the person, because it's like an open,
Are there walls in
yes,
the first floor?
yes, there's walls in there.
Like bedrooms and?
No, it doesn't cut off. It's basically like
An
the kitchen.
open space with a kitchen and a
Yeah.
bathroom. Okay.
I would deem it as commercial.
I'm sorry?
I would deem it as commercial if someone could use it as that.
There was no signs that the business was not operating when you purchased?
No, when I purchased, no. I purchased it vacant, so.
Did you provide any interior photos of the property in your
Um,
application? I don't see any.
I don't believe we did, but I couldn't pull up.
I can't take it.
Okay.
Now I can. Do you have any idea when that first? Oh. When you purchased it, was it occupied?
No, no one was in it.
Do you know when the last time someone was in it?
I don't know. Yeah. When I purchased the home, it was given to me all vacant, so,
And that was January of 2022?
yes.
So it's already been it's been 2.5 years.
No, January 2022. Oh, no, you're right. No, you're right. Sorry.
So it was vacant when she purchased it. We have to find that the commercial business has not been operating for.
It's not a valid use. Conditional uses, if they're discontinued, they expire and you can't restart them if they've been abandoned, which means that they've not been in active use for 2 years.
So no, we have no tenants. We have no indication of any commercial use when she bought it. Seems like to me the commercial use has been abandoned.
Yeah.
Right. I'm trying to think if, back to previous cases where we've had this, I think we've approved it based on the physical structure of the building having been altered legally to be these two separate units, and that being unique, and that there being a practical difficulty in recombining them back into a single-family dwelling. So I think that is something that could be open to the board as an avenue of uniqueness of the structure based on its history, and the practical difficulty of recombining into, because I think what we can't use is an illegal
Right.
dividing up into two different dwelling units. But if it was legally made into a commercial unit with a residence above, then that has been used by the board in the past. And so I think it's within your discretion to be able to do that here.
There's separate entrances for the two
Yes.
for the two units?
Yes.
How do you get to the second floor?
So it's through, the one, it's right through the front door, and then there's like a side door, so you can go through.
And there's no access as between the two units?
I'm sorry?
No access between the two units? There's separate entrances and no other way to get to other than coming out of one and going into the other?
Well, you can, there's a side door also if you wanted to go into the second unit. So, yeah.
Wait, the side door. So the question is, for the ground level unit, can you enter the second floor from the ground level unit?
No, you can't do it.
Yeah, my question was inartfully asked.
Oh, sorry.
His was a better one.
No.
That's why he's my lawyer. Okay, so, and you said they're separate, it's separately metered.
Yes.
Okay, separately metered. What else I can ask you? If you wanted to make this a single-family house, what would you have to do?
Oh, that would be a major task, just because like I would have to combine everything. Utilities are already separated, everything's already separated. We have to knock down the whole back of the back unit, so yeah, it would be a huge undertaking.
Maybe a lot of structural change
Yes.
internally to have to do.
Yes.
Okay. And I imagine this cost of that structural change would be cost prohibitive?
Yes.
The floor plans that you submitted with the application, are those existing floor plans?
Yes.
Okay.
Okay. Any additional questions for the applicant?
I don't think so.
Okay. Anything else you'd like to add, ma'am?
Just want to say thank you all for hearing my case. Thank you.
Okay, thank you. So this is a property that the applicant seeks to utilize as 2 dwelling units. They are presently separate units, separately metered. There's no access or egress in between, ingress or egress as between the 2 units, other than the separate entrances. So it looks like that commercial space that was there was maintained separately, and it never became a single-family property. And at this point, there would be substantial internal construction, maybe probably even external construction, in order to make it so as a single family, which would be cost prohibitive. So I guess the structure itself is unique for purposes of variance standard. Given that history and given the present configuration of it, the second here, standards. I'm sorry, let me just ask you another question. There's no, as built, there's no space for parking,
No.
correct? On site? All right. Okay. The uniqueness of the property as described, as I described it, present a practical difficulty in complying with the bulk regulations. One, parking, there's no space on site. We don't require applicants to reconstruct or tear down portions of their building to create parking availability. Again, the as-built nature was not, the unnecessary hardship or practical difficulty as a result of this uniqueness is not the fault or caused by the applicant. She purchased it as is. It's caused by the code. The practical difficulty is caused by the code, by no intentional or inaction of the applicant. The purpose of the variance is, I've not heard, and the evidence doesn't bear out, that it's exclusively based on a desire to increase the value or income potential of the property, rather to put a practical use to the property, to use it in a manner that you're able to do so. The variances would not be injurious to the use and enjoyment of other property in the immediate vicinity. There's no evidence of that in the record, nor is there evidence that it would substantially diminish or impair property values in the neighborhood. The variances requested appear to be in harmony with the purpose and intent of the code, city code, and there's no evidence that I see in the record that the variances would be detrimental to or endanger public health, safety, or welfare, or be in any way contrary to the public interest. So I'm a yes for the application.
I'm also a yes.
I'm in agreement with the facts. I'm a yes.
Also have no issues here. I mean, yes, thank you.
Also, yes, thank you.
Thank you. Thank you, everyone.
Can we go off the record for about 5 minutes? It's okay.
You are off record at 2:34.
All right, folks, we're going to go back on the record soon.
But this was months ago.
Ready to go?
Yes, sir.
Back on the record at 2:49.
Okay. Calling case number 2024-159, 3504 Buena Vista Avenue. Mark Warheim. Is he in here? Okay, here we go. This is a request to construct a two-story rear and a third-floor addition requiring variances to bulk regulations. Is that correct?
Yes.
Okay. Let's get the witnesses sworn, please.
Raise your right hand. Are you testifying? Do you swear or affirm under the penalty of perjury that the answers that you give and statements that you make are the truth? Thank you. You've already spoken to us, Mr. Spell your full name.
Mark Warehime, MarkWarehime.
Here from staff and planning.
I don't believe planning has a report for this one. Our report is 2 variances are needed here. Minimum interior side yard, 10 feet is required, 3 feet is proposed, so it'd be a variance of 7 feet, and maximum lot coverage, 35% is allowed, 77% is proposed, more than double, and a variance of 42%. And just like the previous cases, the board needs to find uniqueness and practical difficulty with respect to the variance request and this particular property.
Okay. Tell us about your project, but let's start with what is unique about your property.
The uniqueness.
Yes, sir.
I've lived on the street for the 69 years I've been alive. I live 2 doors up on this property. I originally bought the house for my daughter and my son. Lived a couple doors from me. We've all lived in the neighborhood forever. The existing house has no sanitary or water plumbing in the house.
Sir, can you turn your microphone on, please? Hit the button there.
Yes.
There you go.
Green light.
Sorry. And the city water main comes off the front of the house, and that is the only plumbing that comes in and goes to the back of the house. The existing house has, from the 1900s, I presume, has only a 6-foot by 16-foot summer kitchen and bath. The sanitary line comes out of the back of the property. The gravity sewer comes down an alley behind the house and comes up the property and just comes into the summer kitchen and goes up along. You can just see it. It goes up through, it turns into a combination vent. It's a sanitary line with vent. The only plumbing in the house is in that makeshift little stand-up, has the old cast iron sink in it, has a little stand-up shower and a toilet and a rickety old stove. That's the whole 6-foot addition, which is the bathroom and the kitchen. We wanted to be able to tear that off and add a full-size kitchen and bathrooms for the first and second floor where there's none, and it exceeds the variance. Like I say, my son has a 6-month-old, and I'm raising an 8-year-old. My daughter just passed away recently. She was a city firefighter. But anyway, he's going to help me raise another child at my age. So we wanted to put a big enough thing where 5 people could, live in the house, the same family, but have it big enough with bathrooms, which there's none on the first or second floor, that we can use and make everything functional. So with babies and young kids, we could put a substantial addition on.
And so what I believe I hear you saying is that the plumbing in the house is relegated to a small portion of the house?
Yeah, a 6-foot summer porch addition on the back, yes. There's no sanitary vent plastic. The cast iron comes through the backyard and up the side of the house. There's nothing from the back of the existing house now to the front. There's nothing but the 3/4-inch city water line that runs through there and goes to the back of the house.
Plans. Looking for your plans here. Would you say that you're seeking this construction basically to have a larger house to accommodate more people?
Well, we want to put in bathrooms. The one that's there is really not usable. It's a little 24-inch square fiberglass little stall and a toilet that are in 6 foot, so they're pretty much back to back. And the kitchen only has the old freestanding cast iron that's about 48 inches and a small, almost like an apartment size range. That's it for the plumbing and kitchen in the house.
Did you provide pictures of this interior in your application?
No, the contractor, I didn't know I was supposed to. He filed the plans for the permit, and then we had to file for the variance. And he just, not to use, he's a city firefighter, so he couldn't be here today, but he just told me that you guys said it was too large and I would have to go down and apply for a variance. He really didn't say, I thought he told me I'd have to shrink it a couple feet. I'm like, well, I'll go for a variance on that. The existing house is up against the fence of the property line as well, so that's just how they built the house. My house, 2 doors up, is the same. I only have like 18 inches on one side. I only have like 5 foot on the other. And I've been there for 50 years.
Did you look at plans to do an addition that would be within the bulk regulations?
I just had them drawn up by an architect and give them to the general contractor, and he said he would just file the permit because he was licensed. I didn't know what I'd have to shrink the addition. He never told me that. He just said it was 1 or 2 feet, and I'd have to apply for the variance, so that's what I did.
So I have a couple questions. So the chair asked about uniqueness and practical difficulty, and you talked about your utility lines that come through the front. Is there, to your knowledge, is that different than any other property in the area?
Other than my house, honestly, I don't go in, and I know my parents' property that's across the street, the sanitary line, is also in the back. So I don't really can't answer that honestly.
Does that uniqueness, or is there a reason why that gives you and your property any unique difficulty?
Yeah, there's only bedrooms there now.
Well, no, I'm talking about that utility line specifically. Like, how does that affect your property?
Well, there's no way to add or do any renovations in the front of the house. The sanitary line comes in and just comes up. It actually, if you walk to the back of the house, it actually comes up one back. It does not even protrude into the original, I guess, 1900 structure that was built in 1900. It was always at the back of the house, which makes it, I don't know how I don't know how I'd get it, I'd have to bore through all the walls to try to get a sanitary line back into the house to make any kind of kitchen or bathroom in the existing house.
What your existing house already has service to all those specific areas. You have a kitchen, you have a bathroom.
No, there's
No,
nothing
there's no
there.
kitchen and no bathroom in the existing house?
No, there's nothing. There's 3 bedrooms, the living room, dining room, that's it. They, it was only 2 older people. They only had that summer kitchen that's about 6 foot. That was their bathroom and kitchen.
Oh, that's unique if I haven't heard it before.
Yeah,
Yeah, the only plumbing, so just so I understand, the only existing plumbing is in this summer kitchen area.
correct. And that goes out the back. The city water main, the 3/4, comes in the front, but runs
Yeah,
through the basement back to the summer kitchen,
So
and they
you-
cut the
yeah.
back of the house
Okay, so
just for an
there
entrance.
is a kitchen. There is an existing kitchen in the.
That's
on the
6
property.
foot, yeah, and that's
It's
6 foot.
small.
I couldn't read it.
Tiny,
Where could I see it?
tiny. With the sanitary line there, you almost bump your legs trying to get to the stove.
yeah.
I got it. I can get it. I see it.
Here is that you're gonna build something that beats all the guidelines.
Yeah.
To my colleague's a point, were there other homes built that way? Are there other homes built that way in the neighborhood?
Mine's not, mine,
Putting aside yours.
oh,
But you're on the same block.
well, my parents' house, yeah, I live 2 doors up, I live at 3510. And my parents lived, well, they lived at 3515, they passed, but all their plumbing came from the front. My parents' house, the sanitary line comes off the front street with the water. So all the other houses on that side of the street have the plumbing coming off the, we'll call Buena Vista, the main city street, the services come in. Mine goes out the back towards what they call Ash Street. There, and only the water line, for some reason, comes in that way.
And so just based on where the plumbing is now, without a significant expense of like relocating the plumbing, the only place to put a more modern bathroom and kitchen is at the rear of the house.
Right, tear off the old 6 foot and put
Yeah.
on a new addition, yes, ma'am.
Have you tried to make this new design in addition to your property fit within the allowable setbacks?
The general contractor never told me how far I'd have to shrink it. Like I say, with no bathrooms, that was the first thing we were trying to put in with multiple kids, was something on the first floor and for the adults and the kids on the second floor.
May I add, I'm a friend and
Engineer.
I'm an engineer by profession. I worked for the city for many years. I ran the Department of Transportation, and I came with him. The intent in here is to add this and make the whole house to meet all rules and regulations of the city, you know, because his son can move in with the 2 children and assist him in raising, at his age, raising his grandchild. But that's exactly what the intent in here is, and we will review these. I haven't seen the plans, and but
see-
we'll review this and we'll meet all the requirements, whatever it is. It's the department will guide us in this. We asking for your assistance in order for us to be able to do that.
Okay, in order for us to give you assistance, we have to make certain findings, right?
Yes.
We need his name.
Yes, if you could state your
George Perdikakis, P as in Paul, Erdikakis.
Concerning they never tried.
Yeah.
part of what the uniqueness issue goes to is whether or not there's a practical difficulty, whether or not you can't do something along the lines of what you want to do, but be within the bulk regulations. What I'm hearing you say is you never considered doing that because the request was to a contractor to create an addition, and the impetus for that is to accommodate a larger property because you had more people that are coming into the house.
Well, we can't, I'd have to spend $50,000, $60,000 to try to go through a 2-foot wall just to bring the sanitary lines back in and try to convert bedrooms into bathrooms. I think that's
But could
really
you,
unique.
could you do additional construction or renovation and be within the bulk regulations that exist?
On setbacks of what the little that I have seen, he's gonna have to get a variance for the setback.
Well, that's kind of what we're here for right now. Okay, well, I think the question here is that, can you do this addition within the bulk regulations? I think the answer here is, my opinion, I think you should investigate that. I think you should investigate that. You're asking for a very substantial addition that looks like a very great addition and very luxurious addition. Can you fit that within the bulk regulations? And I think what you'll find is that you could very possibly fit this program in a smaller footprint. And I would ask that you have a discussion with your architect or contractor to see if you can do that. I just don't see anything unique about this, even still with your description of how your utilities come in.
Can I respectfully ask for a postponement, and then I promise you that we'll come back next month with all the information.
Is there some dimension or is it average? I'm not a residential contractor. per se.
I know what I
I'm a
can.
wastewater treatment. I work at Back River, places like that.
Here's what we'll do. We'll certainly grant you the opportunity for a postponement.
Okay.
Because again, we can't make the case for you,
Okay.
right? And one of the questions clearly we would ask, because we want to know, is if you're going to do an addition, if you have a need to do that, have you tried to do it without getting a variance? If that means shrinking the program a little bit, but right now, it sounds like you don't know. So,
The question could also be, could you do it with a smaller variance than the one that you've asked for too?
Right. It could change the size of the variance, or maybe no variance, so.
Something that the board has to find is that this is really necessary in order for you to use the property. And so,
I promise you that we will have that
So-
available to you. We just respectfully ask for a 1-month postponement.
However long
And
you
we'll
need.
come back and we'll make the presentation.
Awesome.
to you.
That'd be
Thank
great.
you very much. I appreciate it.
The board okay with that?
Thank you.
Postponement?
We're good.
Great. All right, thank you so much.
Thank you.
All right. Okay, can we down to?
Mr. Hurdle is
Oh, yeah,
here
that's
for
right.
his case.
Come on up, Mr. Hurdle. Going to recall case number 2024-162, 482 South Bentlow Street. Mr. Abraham Hurdle is the appellant. The request is to use the second floor as a restaurant requiring conditional use approval, correct? Correct. Let's get the party sworn, witnesses sworn.
Does the board have copies of everything? Because I have duplicates just in case.
They should, but yeah.
You raise your hands. Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you. I guess we'll get names, spellings. Oh, actually, no, I can do that now. Ma'am?
Natasha, L-A-T-A-S-H-A. Burgess, B-U-R-G-E-S-S.
Could you turn the mic on your table, please? Thanks.
B-U-R-G-E-S-S. Sir?
Sabine Burgess, S-A-B-E-I-N, B-U-R-G-E-S-S.
I'll hear from staff and planning.
All right. I don't know where Eric went, but, so the request is to use the second floor as a restaurant, which would require conditional use approval. We've heard this, cases on this property several times in the past couple years. So there's an existing tavern on the first floor. And so that will remain. as a non-conforming use in a residential zone. The request is to add a restaurant use to the second floor, which is allowable as a neighborhood commercial establishment. We have a history of this being used for commercial use throughout many decades and even today. So I think the board, the request has been a few different times to expand the existing non-conforming tavern from the first floor to the second floor, which the board has denied once, and then a second application for the same thing was withdrawn. So I hope Mr. Hurdle can explain to us how there's going to be a tavern on the first floor and a restaurant on the second floor, and how that is going to work. That's what it is for me. I think actually, now that I'm thinking about it, Mr. Tiso told me that planning chose not to submit a report on this case.
No news is good news.
Okay, Mr. Hurdle.
Thank you. I'm not sure that I've been here for the denied expansion to the tavern on the second floor, but I was here for an attempt that we withdrew. I know that. And we were here previously to formalize the pre-existing live entertainment that has been going on for decades, and the board had approved that hearing. Currently, there is a small kitchen on the second floor. That kitchen, as part of this plan, would be significantly expanded. This is a location in an area where the hours were cut back as a result of a state law change that reduced the seven-day tavern?
Yeah.
7-day tavern from 2 a.m. to 10 p.m. As a result, their business operations have in many ways shifted. In this case, they've started to do significantly more food. So while they are a tavern and they have no food requirement, food has been something that their patrons have requested more and more of. We cannot expand the tavern use. And the difference between a tavern and a restaurant, at least by liquor board standards, would be if it's a restaurant license, you have to have 50% food. And if it's a tavern, there's no requirement at all. I'm not sure that today they would be on the first floor meeting that 50% requirement, but we're not applying for a restaurant liquor license. We're applying for a restaurant use in the second floor. It is my client's proposal that the second floor would be all seated dining. People would be ordering food up there. There wouldn't be an additional bar or bar service up there. People could order alcohol with their food. We would still have to go to the liquor board at some point to either expand this license use or get a restaurant license and then move the tavern license away. That is that is something that we haven't gotten to yet. We cannot even make an attempt until the zoning board has approved the expansion to that use. Again, long-term, my understanding is because we can't have the tavern license applied to a restaurant. So we would probably have to sell that license or forfeit it in some capacity and get a restaurant license. Again, a restaurant license would require capital investment, 75 seats, which they would meet that requirement. And at that point, they would be required to have at least 50% food. And I'll have my clients speak to the percentages, what they are now. But my understanding is the existing kitchen, they have significantly outgrown it. It was more of a service kitchen as opposed to a full kitchen. And their plan is to, going forward, just offer more food. The neighborhood changed in many ways. People are looking for a convenient, fair-priced, reasonable product that they can get to in walking distance. This is probably not going to be a destination location. It's a neighborhood bar, a neighborhood restaurant, and they plan to keep it that way, and they plan to shift more towards food. The margins are, in many ways, getting better on that. And I think they do a lot of seafood, too, now.
Yeah.
Yeah. Ms. Burgess, what is the food to alcohol sales at this point?
Right now, it's not a lot of food being served because we don't have the kitchen. We need a bigger kitchen. We need more space. So I would say like right now it's maybe like about 25%.
And if this was granted, and after we got the liquor license changed to a restaurant, you would follow and obey any requirements to serve 50%?
Yes, of course.
And you guys do a lot of seafood now?
Yes.
And you anticipate that increasing over time?
Yes.
At this time, we would ask if the board has any questions to address any of the concerns going forward.
So just to be clear, Mr. Hurdle, not only does the liquor license for a restaurant license require 50% of food, but so does the zoning. The zoning code also requires that average daily receipts from sale of food exceeds 50% of total average daily receipts.
And my understanding is, if I may, that we couldn't have alcohol on the second floor unless we were to, and you may know this perhaps as well as I do, you're probably the second best person in the room for this. The second floor, for us to use it, we'd have to change out that tavern license because we couldn't shift it upstairs.
Yeah, I think you're right.
So we'd have to follow those rules that follow both departments in theory.
So I guess what are the steps? So if we approved a restaurant on the second floor, would you operate that without alcohol for a period of time and until you
Till
could get
you
the
got
liquor
the-
license figured out? I'm just curious about what steps
Despite-
do you plan to take?
Thank you. Well, despite the fact that I think we would like to do just that tomorrow or the day after the decision comes out and presumably after we get permits the same day, building these things just doesn't happen as quickly as the liquor board does. My anticipation is if we were to get approval today, the decision typically is about 30 days. We are still chasing down the inspections on the previously granted live entertainment, which, speaking to someone downstairs, we have to finish, and then we have to start this kind of conglomerate. And at that point, somewhere in there, we would apply for the liquor board use, and I'm still gonna, it is my anticipation that the liquor board will have and hold a hearing long before we get a final use permit to allow any sort of operations on the second floor beyond what the current kitchen is today.
But if I'm sorry to take up so much board question time, I'm just confused. If I'm understanding correctly, the intended outcome is that everything will be covered under one restaurant use permit in the nearish future.
That's correct.
Okay, great.
And restaurant liquor license.
And so to clarify, this is step one.
I think we've had a couple steps already.
Sure.
Yeah, I
But
think-
like,
yeah,
in
it-
order, like, in terms of you need this decision before you're able to go before the liquor board.
Yeah, it's certainly my preference to go to the liquor board first and then force you guys to agree with what they do, but we can't do that anymore,
No,
so.
you're not allowed to do that anymore. We changed the law so that you couldn't do that
Can't go
anymore.
to mom and then tell dad that she already said yes. It's not, we can't do that anymore. There are many steps. I look at it as a more fluid situation because there's a lot of things go sideways in the city in terms of inspections. I anticipate there's a distinct possibility we'll have to get sprinklers into this thing, and it's gonna be it'll be a different battle we have to fight, and also it takes some time. So again, assuming that we're gonna have sprinklers, which I really don't see us not needing a sprinkler system on the second floor. Given the timeline that that's gonna take to possibly get a developer's agreement, get it dug up, get the pipe in, get the lines in, get that system hooked up to their existing or to the new fire hood that'll go in above the kitchen, I would anticipate they wouldn't be in a position to get a use inspection for probably 6 to 9 months, best case scenario. But in the meantime, we will get all the liquor board things approved, get that developer's agreement, and it's gonna be some time before that second floor is operational. I am hopeful it is in within a year, but it's difficult to me to provide 100% assurance to this board because I've been here myself on extensions and there's any number of things that can come up. But I anticipate 6 to 9 months before it's operational. We'll get the liquor license before then.
What are the anticipated operating hours of the restaurant?
Between, let me say, like, about 12 to 10.
I do believe that the restaurant license, and again, maybe Ms. Witt might even know it as well, I do believe if they fall into the restaurant category, that they may be permitted to stay open later than under a tavern, but I'm not certain under that
That's
requirement.
fine. It just gives me an idea.
But there's not going to be there's no intention to operate a tavern and a restaurant. It's going to be.
They will have to choose at some point in terms of the liquor license. Otherwise, it will be presumably food only upstairs. And I anticipate that would be challenging to monitor and enforce in any number of ways.
So as you envision this, when the restaurant is fully operational and, well, fully operational, what then with regard to the downstairs space, what is that gonna be? It won't be a tavern anymore, right?
There's, for lack of a better way of describing it, a lot of taverns in parts of the city are used as maybe a little more packaged goods focused than, say, sit down at a bar and not have food, which I think was the purpose of it. Not that this would be their purpose, but a restaurant license doesn't restrict much. You can still have a bar. Someone can still come in, get a drink without ordering food. I anticipate that the downstairs layout will stay much the same, which is at the moment, tables, chairs, a bar, etc. They could still do limited packaged goods over the bar if they were to desire. I don't think that's a huge part of their business model now. I don't anticipate that would become a greater part of their business model going forward. So operationally, for them, going from a tavern to a restaurant will probably give them better hours and will give them more space to sell food, but I don't think it will hamper their existing liquor operations in any capacity.
So you're really just trying to utilize just trying to understand the process here. If you're really just trying to utilize the existing license that you have while the second floor gets renovated and prepared, and then transition to a restaurant liquor license, for lack of better terms.
That's the term.
And then you'll be serving food and alcohol on both floors.
Again, my anticipation is if we were approved today, sometime in early October, we would probably get the decision. We would file for the liquor application immediately, and we would probably have a hearing late November, early December. That would be long before any sprinklers are in any way installed, clarified, permitted. We would have the liquor license for the restaurant approved conditionally upon a use permit issuing, long before the build-out would be complete and a use permit for occupancy in any capacity in the second floor would issue.
So it's one business.
Yeah.
With one liquor license that serves both food and alcohol.
Yeah.
2 floors. Okay.
Yeah.
Okay.
So you're asked, again, the hours. You mentioned 10. Mr. Hurdle, you suggested there may be within the code some.
Tavern licenses have been restricted in the last few years in certain small pockets of the city. I apologize as the person who probably should know this in the room, but I don't know that that applies to people with a B license, which is the license they would be getting. A restaurant is a B, this is a BD7 that they have. I know that the taverns have been restricted. I would be guessing if I said that it would, again, my belief is that they can expand their hours, but I'm not sure that that is the case. So I would be remiss to say that they absolutely can. I don't know that they would go beyond 12 anyway. Yeah. They play an active role in the community. They've talked to the community. Part of this shift is at the community's request.
So for purposes of perhaps granting you relief, would it be safe to say that the hours are till midnight?
Yeah.
For the restaurant?
Yeah.
We would abide by whatever the law is.
Yeah.
I just need to check it. I apologize that I just don't know what if a B is restricted in those pockets. I know there's one on North Avenue. I know this is one in West Baltimore. There's a couple of them, and I just couldn't tell you what it is for a restaurant. If the restriction is 10 p.m., they would close at 10.
Well, the restriction would apply to alcohol sales, wouldn't it? Or would it apply to the entire business if it were a restaurant and could serve food later than that? I don't know.
I think late night operations cuts them off at midnight no matter what. I don't know that the law that controls the hours applies to restaurants or just taverns and A licenses. I'm not sure it's come up before.
Are you saying midnight then?
I believe that they would like to be operational till midnight. If in fact the law that I don't know says 10, it would be 10 for alcohol sales, and I anticipate they would cut off food sales at that time.
midnight unless the law mandates earlier?
Until 10 o'clock is the cutoff at the moment.
Okay.
You're asking us to make a lot of assumptions here. First of which is, let's assume that you guys do get a liquor license or whatever. I'm worried about how can we ensure that the tavern use and the restaurant use do not mix.
Sure, that's an excellent question. So functionally, the tavern use would be of no benefit. Right now, there's no food requirement at the location because it's a tavern. They can serve some packaged goods over the bar, and they can serve bar patrons who don't order food, and they can serve seated patrons. And if they'd like, they can serve food. If they get a restaurant license, all of those things continue on, but they must meet a 50% food requirement. That's the requirement. So they just have to add food. The liquor board does some inspections on this. It's difficult to tell you that those inspections are perhaps maybe as thorough. I know that I've had some clients run into some issues with, I think, a zoning or use inspection in terms of showing receipts for food sales. Again, right now, they would have to pick because we can't, the liquor board, when they process an application, the first thing they do is they call Mr. Veal on the first floor to verify that the use has been permitted. And if we were to try to expand the tavern use to the second floor, that wouldn't happen because you guys wouldn't grant that and Mr. Veal would say no. So that would never go anywhere. As a result, the only way for us to have any alcohol sales on the second floor would be for us to, again, forfeit or sell the tavern license and get the restaurant license. I'm not a person who likes to work in absolutes because things can be unusual and there can be curveballs. I would say that I have a high degree of confidence, as close as I could be to a certainty, that if we went to the liquor board and told them our goal is to add food, which the neighborhood seems to desire, and therefore reduce the tavern license, which I think we all know that taverns tend to be a little, for some reason, they tend to be taboo versus a restaurant. Again, the actual in-practice use is just that it's the same thing plus food. I anticipate the liquor board would be overwhelmingly comfortable with that concept. Again, if we can have our hours be midnight, that would be great. And I do apologize that I just can't, I don't want to tell the board the wrong thing, on the record certainly, that the hours couldn't be restricted or couldn't be expanded till midnight. I know that that would be, more hours is better. I think that's something they've run into at the moment. That isn't the driving force behind this. It's that it gives them more things to sell. More things to sell means bigger tickets, more sales, more revenue, and there's more space as a result of this. Plus the kitchen would be significantly expanded and modernized. Everything, every part of this business benefits from this change. And I think the neighborhood benefits from having a genuine food establishment in the area that they can walk to, as opposed to now where it's limited food, perhaps more limited hours. And again, it's a focus on alcohol, whereas this would be a focus on food.
Thank you.
Do you have any concerns about the operation of both the restaurant and the tavern together in terms of number of people, alcohol upstairs, downstairs? What issues arise as a consequence?
Yeah, I think it's, to say that there aren't any concerns about an establishment that serves alcohol is foolish. I think that there are many places where the patrons behave kind of universally. I think that comes from the top down with the management. If there's someone acting out in any way, you got to put a stop to it. And I think that the more you do that, the behavior of all the patrons kind of falls in line. I think places that have problems tend to have more challenging management. They've been running this place for, I believe, about 2 years now. Been about a year. And this location has been in existence for a long time. It's not a rowdy place. It's not a nightclub. It isn't a lounge. It's a neighborhood bar. I think when we came here 2 trips ago, when we were talking about the live entertainment, which I want to say we were here once or twice on, there were a bunch of people from the neighborhood who were here to testify about how they always go out on Tuesdays or Thursdays for karaoke. They've been doing it for literally decades. This is not that karaoke isn't exciting, but this is not this isn't a dangerous crowd in my mind. This is a neighborhood bar. This is the neighborhood's bar.
Yeah.
And this way they can serve food to those same patrons. We do plan to have additional staff, given the additional space. My anticipation is there'll be 2 or 3 more servers. They will all be alcohol awareness trained to make sure that there aren't minors coming in. I still don't think this is a place where minors and underage drinking is going to be a prevalent issue or something that they need to worry about. It's something to always be conscious of at an alcohol establishment. But staff will be trained in service procedures, carding, and things of that nature, and they'll have someone at the door at all times, which they do now.
Okay, the restaurant would have its own entrance?
No, I don't believe so. No.
You go through the tavern?
Yeah, you go through the front.
You go through the tavern and up to the restaurant?
Correct. It's going to be one operation. It's just the second floor that we're adding.
Yeah.
I'm sorry, I thought my question was clear that.
Sorry, did I miss?
No, I think you answered it right. I just want to make sure everybody on the board understands as well, is that at the end result, you're going to have one establishment, one liquor license, and that's for a restaurant.
Yes. Correct.
Yeah.
So the
I am
question here
hesitant.
was during the interim, while this is
Right.
getting constructed and renovated, et cetera, that it's going to be a tavern license that eventually the applicant's going to transition that into a restaurant license.
Yeah, so the idea being, go ahead, Leon.
If they can get it, yes.
Yeah,
In the simplest possible terms, right now it is a tavern on the first floor.
Right.
It's going to stay a tavern until the second floor opens, and long before that's going to happen, because it's going to take time.
Yeah.
We will have a restaurant license that is issued conditionally upon a use permit that'll require sprinklers, any number of other things. And then the whole place will just be a restaurant. When I filled this out, I put tavern on the first floor and then restaurant on both, because I'm always just very hesitant to forego a non-conforming use on the application, because once it's gone, even if it's just due to some confusion,
no, I understand.
that's my
Yeah.
concern. Ultimately, it's just my
Yeah.
concern, that's all.
And I understand the plan, so in my mind, to me, this is pretty administrative and just really trying to make sure that there's a second story on this building that currently isn't zoned for this use, and we need to make the initial decision that sets them on this course. And there's lots of other guardrails in place that will actually start to dictate the operation. And that we're here today just to talk about that, similar to a live entertainment license, this is just an approval that you have to get to move on, and then everything else will sort of be in other people's hands.
Absolutely.
So I feel like I've heard what I need to hear.
Okay. Anything else you want to add, Mr. Hurdle?
I always appreciate the board's time and candor, and I especially appreciate their patience when I have to be before Judge Cooper.
Okay. Very well. Thank you. So we're here on a request for conditional use. Wrong case. For this restaurant, got a lot of background about what this project is, how it's going to take time to really develop. But really, it's a conditional use approval and standards associated with that for the restaurant use. So with the establishment, location, construction, maintenance, or operation of this conditional use, the restaurant on the second floor be detrimental to or endanger the public health, safety, or welfare. I think no, given how it's described. We don't have anything in the record which suggests that the operation of the tavern, for example, has been problematic. That would suggest additional problems or new problems for a larger venue, ultimately with a liquor license. But I don't think the record reflects any detriment or danger to the public health, safety, or welfare. The conditional use is not precluded by any of the law, including an applicable urban renewal plan. The authorization for the conditional use is not contrary to the public interest. you come here for the authorization to do the things people normally do, which is, have an operation that the community appears to desire, and they want more food, so give them more food. The authorization, I believe, also is in harmony with the purpose and intent of the code, again, for the same reasons. I also believe that to the extent there are adverse impacts associated with this restaurant operation, that those adverse impacts would not be above and beyond those inherently associated with a restaurant operation anywhere else within the zone. So for those reasons, I'm a yes. I think we established that on the condition that the outside time would be midnight or earlier, according to the legal mandate.
I'm also a yes.
Also, yes.
Before voting, I see here it says proposed hours are for food service from 11 a.m. to 1:30. Was that brought into effect and then we settled on 12? Or will that occur if the tavern becomes a restaurant tavern license?
My understanding and the intent of my question was, as operating as a restaurant, when would it cut off? Or what would the hours be?
We've talked about 12, and we would honor that if that was the grant of the board. I think that sometimes when I fill these out, I fill them out as optimistically as possible and submit them. And Ms. Whit will correct me sometimes.
All right.
Okay. I'm a yes.
I'm also yes.
Okay, thank you.
Thank you.
All right, good luck to you.
Appreciate it.
Can we take a short break?
Sure. Off the record? You're ready to go back on.
Okay, we are back on the record, 341.
Okay, calling case number 2024-028, 711 West 40th Street. Ms. Tilden is here on behalf of the appellant. This is a request to use a portion of the premises known as 729 West 40th Street, number 101, as a restaurant with live entertainment requiring conditional use approval, correct? Okay. We'll get the parties. You know what? I'm going to swear everybody. Get everybody sworn, and then we'll get reports.
Anybody who plans to testify should stand and be sworn. There's opposition.
If you can have everyone raise their hand. Do you swear or affirm under the penalty of perjury that the answers that you give and statements that you give will be the truth, the whole truth, and nothing but the truth? Thank you. And we'll get names and spellings each time when someone comes up to speak, so if you try to remember to do that without being asked, that'd be great. Otherwise, I will have to jump in.
Very well, thank you. Hear from staff and planning?
All right, so the request, as you said, is to use a portion of the Rotunda development as a restaurant with live entertainment. The restaurant is by right. The live entertainment requires a conditional use. It's zone C2, and obviously there's significant community opposition related to noise and traffic. And I'll turn it over to Eric.
So for planning's report, you've heard the wind-up here. We recommend approval of the appeal subject to a few conditions. Number one, the outdoor dining plan and capacity is approved by the Department of Planning. I did look at the proposed outdoor seating plan earlier, and it looks like it's in good shape, but we can look at a copy more formally later. And then also, in addition to meeting the requirements under 14.329 in the zoning code, the outdoor dining should be subject to additional conditions as follows. There'll be no outdoor bar, no outdoor music, jukebox, or other form of entertainment, and all patrons must be seated for dining and served by wait staff. And those are typical conditions that we normally request for outdoor seating, and with those, we recommend approval.
Thank you.
Also, sorry to jump back in, but there is a letter of opposition that was just added to your file here from Councilwoman Ramos, which was submitted this morning, and that's it for me. Thanks.
Okay. And Ms. Tilden, you have a copy of this letter from Councilwoman Ramos?
Yes, I do. Actually, thank you, Ms. Witt, for sending it over. I think the councilwoman must have just forgotten to CC me on that one, but I appreciate you forwarding it, Ms. Witt. Great.
Proceed,
Well,
ma'am.
Yes, of course. So Drew Tilden of Rosenberg Martin Greenberg here on behalf of the applicant. I'm joined today by Mr. James King, who is a representative of the applicant. I am sure that the board has had the opportunity to some extent to review the extensive letters on file. So I will start by giving you a rundown, and then I'd like to sort of address briefly the conditional use standard and also some of the community outreach that we've done thus far and sort of where we've been, where we're at now. So what we're requesting today is conditional use approval to allow the operation of live entertainment, accessory live entertainment on the property. So if you will see in your file, I think the most helpful exhibit would be exhibit number 2, which is the Rotunda directory map. The building and sort of patio area that's highlighted in red, that is where the proposed use is going to be. So it'll be a restaurant, a farm-to-table restaurant that will operate for lunch and dinner, and then on Sundays for brunch service. And then there's also going to be a small private event space with the capacity for approximately 100 individuals. And then there will also be a couple of sort of small private dining rooms within the restaurant itself.
Can I interrupt you for a second? Does the opposition have a copy of your materials? Or can you give them?
I have not had the chance to meet opposition's counsel,
Oh, okay.
but we do have a copy for them.
Okay. Do they have it or?
I don't know who they are, but we have copies for them.
Okay, I'll just give it to them.
Perfect. Thank you. Sorry about that. So the proposal is a restaurant with an accessory event space to the rear. There are also floor plans included in this. Part of the operation will also include an outdoor patio. There's going to be pretty actually substantial landscaping improvements to the area. The outdoor patio will be covered. There's going to be a 3-foot knee wall. That is also included in your exhibits in the renderings. So it is technically outdoors, but it does not feel like your typical outdoor dining in Baltimore where you're just kind of set up at tables on the sidewalk. And now that you have a sense for exactly what it is proposed and where that is going to be located, I just want to note that this is a conditional use application for the accessory live entertainment. This does not have anything to do with the restaurant, which is permitted by right. The off-street parking, the rotunda itself has an abundance of off-street parking. The accessory live entertainment does not require additional off-street parking under the code. The restaurant is obviously not required to provide additional parking. We are not here to address delivery hours, which are related to the restaurant. We're not here to discuss any sort of staff loitering, construction, residential infrastructure. All of that is related to the restaurant proposed use and not to this accessory live entertainment application. I do also want to note that the conditional use standard as set forth in Schultz v. Pritz is that the use at the particular location may not give rise to adverse effects above and beyond those inherent to such a use at any location in the zoning district. So that means that this application must legally be approved, and its denial would be arbitrary, capricious, and illegal unless so long as the use at this location, the live entertainment, is not going to be any worse than any other C2 zone property. And we understand and recognize that there are homes that are adjacent to it, but that is inherent to a community commercial district. The C2 district is designed to be adjacent to residential properties and to actually provide commercial uses that will serve the residential properties. In terms of the community outreach that has come up thus far, I will note that we did not initially reach out to the Hamden Community Council, which is our policy. We always reach out when we submit an application to the applicable neighborhood community association. But given the fact that this is in the Rotunda Shopping Center, where there are already 2 weekly live music events that are actually outdoors, it didn't cross our minds. And we really very much appreciate the fact that the councilwoman reached out in advance of our initial hearing date in June and requested a meeting. And we said, of course, we're happy to share our plans. She alerted us that there were community questions and concerns. We attended that meeting in June just to share our plans. The councilwoman raised the issue of potentially adding conditions to the approval, and we said, these are all our plans. We're happy to condition, as there was an oral presentation from myself and Mr. King. We're happy to condition the approval on the things that we're already planning to do. There were questions about hours of operation, specifically because live music is proposed outdoors on the patio during happy hour. And there was a question of, well, what is happy hour? And so the response was 4 p.m. to 7 p.m. We shared in response to the parking concerns that although it's not required, the plan is actually to provide valet parking for customers. And that was what was said. And I think the one other question that we had was that it is going to be acoustic music outdoors. And this could be that in a former life, I was a singer. And so I do know that whenever there is live music, even if it is acoustic, it will be amplified. But I think that was something that when we came back and said, hey, actually, we said 4 to 7 p.m., we would very much appreciate if we could do 4 to 8. We understand that is not what we said. And then we also said, we weren't specific, but the valet parking would be really just for Friday and Saturday nights, and then for large events. And also the acoustic music is going to be amplified acoustic music because singers do generally need to sing into microphones. And I think that we want to be clear that there was never any intention to hide the bag. And I say this as I read through the materials that were on file, and I want to make it really abundantly clear that the goal in this situation has been to be upfront, and which is why we immediately agreed that we're happy to condition these. If it's going to make the community feel more comfortable and be in support of this application, we were happy to add those conditions. I will note that we communicated with the Hamden Community Council after that. We were asked to postpone the hearing so that we could meet and present, which we absolutely agreed to. We postponed, we presented, and we actually, in fact, said we are even willing to remove the outdoor live entertainment entirely. If that is something that is going to bring greater comfort. After our presentation to the Hamden Community Council, we followed up and said, thanks, let us know if you need any more information. We were told even before the meeting that there would be an opportunity to go back and forth and that we should actually leave some time in the event that there were additional comments on the plans. And we learned, unfortunately, that the Hamden Community Council was going to oppose this application. So given the fact that the conditions that we proposed had not alleviated their concerns, we are no longer proposing to add them to this application. We present them to the board at this board's discretion, in that we are happy to have the board condition this approval on any sort of operational needs that the board believes are in the best public interest, but we are not here today presenting specific conditions. So I think with that said, and again, we're disappointed that the opposition came in, and we didn't have the opportunity to continue to discuss other opportunities to bring comfort to the community. We did see the councilwoman's note, again, thank you, Becky, for forwarding that, suggesting that we postpone in an effort to continue to negotiate. We've already postponed once, and we have proposed conditions and were not met with any sort of response outside of outright opposition from the community. There was no, well, we would prefer if you would do this outside of a request to provide valet parking every night of the week, which just financially is not feasible or related to the application. But I think now that I've provided sort of that background on where we are, which I think generally I would not provide at the outset, but given the fact that there is a robust file, it felt necessary. So I guess I will now dive into where we are now. We've received liquor license approval for, not the live entertainment, of course, because it's required that we come here, but we have received liquor license approval for the Class B license, so the restaurant can operate by right as soon as it's ready to go. The rotunda itself is a shopping center located in the C2 commercial district. And it was actually constructed in 1921 for use as a business campus. So this property has been used for non-residential commercial use for over 100 years. It was then one of the city's first mixed-use redevelopment projects back in 1969, and then subsequently in 2013, it was converted into the $85 million mixed-use development that it is today, that we see today. And so some of the uses right now are, of course, the Mom's Organic Market. We have local restaurants such as B&U Noodle Bar. There's an apartment complex, but I also do want to emphasize that there's also a central event plaza, which is directly across the street from the proposed building. And that central event plaza plays host to the Rotunda Rocks series, which is a weekly Friday night neighborhood street festival featuring live music from Baltimore's top bands. And that is a weekly outdoor live music festival. And then there's also the Rotunda Farmers Market on Tuesdays, which also offers live music.
Is that live music amplified acoustic music allowed?
It is not just amplified acoustic music, it is amplified rock band music, as well as amplified acoustic music at times on Tuesdays. The Rotunda website says amplified acoustic and band music.
So that's Friday and Tuesdays, possibly.
That's Friday and Tuesday. And Friday is not acoustic. Tuesday is occasionally acoustic.
Do you know what that live entertainment is tied to? Like, how is that permitted? Is that by special events?
Yeah, so my understanding is that would be a special event permit.
Okay.
Yeah, and it also is seasonal.
Okay.
Yeah. So those are allowed through special event permits and not necessarily as a specific use. It's also not through any individual business. It's through, but I'd like now to turn to the applicant. I think this is extremely relevant, especially in a case like this. So the applicant is a subsidiary of Titan Hospitality Group. I'm joined today by James King, who is the founder. He's been in the hospitality industry since he was 14 years old when he started washing dishes. He's touched every single element of this business. He, over the past 25 years, has opened 22 restaurants. At this point, and on top of that, he's also a 4-time nominee for Restaurateur of the Year by the Restaurant Association of Maryland. He's got several restaurants right now, including actually 2 other Barn and Lodge locations. One is in Gambrills and the other one is in Columbia. The Gambrills location and both of them are both live entertainment, private event spaces, and restaurants. The Gambrills location is directly across the street from single-family detached dwellings. The Columbia location is in an apartment building. Neither of them have received any complaints from residents in the area. It is also likely in part to the fact that it's the group's practice to build strong relationships with the communities in which they operate. So examples would be donating to local organizations. That could be a Little League team, that could be a theater group, that could be a religious organization in the community. But it's very important that they stay entrenched and supportive of the community. Mr. King also recognizes the value of actually employing community members who live in the areas where his restaurants are operating. To that end, Allison Stewart is going to serve as the restaurant's private events coordinator, and she herself is a Hampton resident. I believe also the general manager's son goes to school in the area. So I've given you a bit of background on the proposed use, but I guess more specifically, there's a dining room, a traditional dining room with about 100 seats, 2 14-seat private rooms, an approximately 100-seat private event space, and then an approximately 73-seat outdoor patio. And this project, especially and its build out, is going to involve a $4 million capital investment in Baltimore City. The hours of operation will be 11 a.m. to 1 a.m., Monday through Saturday, and then 10 a.m. to 10 p.m. on Sundays. And now I want to highlight that is the outside window for hours of operation, especially in the event that there is a private event. But generally, weeknights are not going to stay open until 1:00 a.m. And unless there is a private event, the indoor live entertainment is going to be limited to dinner service, acoustic inside, and happy hour acoustic outside. So live entertainment, unless there is a private event in the private event space, there will not be public shows. Live entertainment is going to be limited to dinner hour and happy hour. And I'll also note that while it's not ever been an issue, the Titan Hospitality Group has a policy to station security personnel at the front door of all of its establishments on weekends and evenings, just to make sure that guests feel comfortable. And that is a similar amenity to the valet, which is just another amenity that is above and beyond, where they want to, for the ease of their customers, provide valet when necessary. So the weekends when parking is most likely to be a challenge.
Ms. Stone, I'm sorry, one clarification question.
Yeah.
Could you explain again where the live entertainment would occur again?
Yes, absolutely. So the live entertainment, so there are kind of two elements to this. There is the acoustic music. Pardon?
Go ahead, Ms. Tilden.
Thanks. So there's the acoustic music that is going to be both indoors during the dinner hour and proposed to be outdoors also during cocktail hour. And then there's separately the as-needed, really, live entertainment that would be applicable in the event that the special event space is rented out. And that would be where a full band may come in or a DJ.
And that's only internal?
That's only inside.
Okay.
Full bands are never proposed to be outside.
Now, as you said before, when you say acoustic, that is also amplified, though.
Acoustic is amplified.
Okay, thanks.
In relation to the, I'll figure this out when I look at the plans a little more carefully, but the entertainment space in the venue,
Yes.
where is that in relation to the residents?
Yes. So the entertainment space is at the rear of the venue. So it is closest to the residents, but it's on the second floor.
Okay,
Yes.
second floor rear.
Second floor rear. And I do want to note, and we discussed this at our initial community meeting and also when we presented to HCC, and Mr. King actually passed out his business cards, and there will be a sound test performed before the event venue opens. So Mr. King is going to bring a full band in, do a sound test, and actually test compliance with the Baltimore City noise ordinance. And then any additional soundproofing that needs to take place we're going to work with the architects and the engineers to ensure that additional soundproofing that is necessary. And that is one of the things that we actually offered to condition the approval on initially, but was not found to be.
And those sound tests will occur both interior to the building and exterior to the building?
So the sound test would occur exterior to the building. It would be based on the Baltimore City noise ordinance. And so that would be measured actually from the residential zoning line. And there are decibel levels that are required for nighttime, like after I believe it's 9 p.m. and before 9 p.m.
Okay.
Another question.
Yeah.
This exhibit 5, this is,
That is the front from inside the rotunda.
got it.
Yes.
So when you're driving down past the grocery store, Mom's
Yep, it'll be on your right.
side,
Yeah.
past the.
Yep, it's right between Xfinity and medium rare.
Open when you need it to be.
Yep.
What else? So where I used to be able to park periodically. I think. Yeah. Okay. That's the venue.
But that is the venue.
And there's going to be 2 floors.
There are 2 floors, yes. And so with that, I think I've provided a solid understanding, but I'd like to turn back and with apologies because I know the board has been beaten down by myself and my colleagues many a time with the Schultz v. Pritz standard. But I'm going to beat you down again. I'm going to emphasize again, this is a conditional use application, not for a restaurant, We're not requesting any parking relief. There are no bulk and yard regulations that we need relief from. It is just for the accessory live entertainment use. And the Maryland Court of Appeals has repeatedly stated, and I'll go to the Schultz v. Pritz seminal case, a conditional use application must be approved unless there are facts and circumstances that show that the particular use proposed at the particular location proposed would have any adverse effect above and beyond those inherently associated with such a special exception use, irrespective of its location within the zone. I will go on to note that Maryland courts have repeatedly deemed the denial of a conditional use application absent a showing that the proposed use at the proposed location would adversely impact the general neighborhood to be arbitrary, capricious, and illegal. To evaluate a use's adverse effects on the surrounding neighborhood, the board must review the particular use in light of the property's underlying zoning and evaluate whether the use accords with the general welfare and can be conducted without real detriment to the neighborhood in light of the character of the underlying, in this case, the C2 zoning district. So then if we look to the C2 zoning district and the character, because we are trying to evaluate the proposed use consistency with that, the sections 10-204 of the zoning code states that the C2 community commercial district is intended for areas of small to medium scale commercial use, typically located along urban corridors that are designated to accommodate pedestrians and, in some instances, automobiles. The district standards are crafted to ensure compatibility among neighboring residential, commercial, and entertainment uses. So the City Council specifically contemplated that the C2 district, where accessory live entertainment as a conditional use is presumed permitted, absent a showing otherwise, is appropriate and compatible with neighboring residential uses. So the Schultz standard is intended to be taken in light of the Baltimore City zoning code's conditional use standards, to which I will now turn. 711 West 40th Street is an 11-acre lot that has operated for commercial use for over 100 years. The accessory live entertainment is proposed to be located across from an outdoor event space that plays host to live music events 2 nights per week already. So the character of this property in this area specifically is already one that includes amplified live music. Furthermore, the building itself is historic and it is brick in its construction, and the applicant intends to perform whatever soundproofing is necessary to comply with the Baltimore City noise ordinance. The code does not require operators to provide off-street parking spaces for accessory live entertainment, and the use will not, in itself, create additional traffic. Nevertheless, the applicant, as mentioned, intends to offer valet on certain nights as an amenity to patrons. The accessory live entertainment, therefore, will not have adverse effects on the surrounding area above and beyond those which are inherent to live entertainment that would operate on any C2 zone property. Hamden is a bustling residential neighborhood featuring numerous community-oriented commercial uses. In fact, just 3 blocks south of the property is the stretch of 36th Street known as the Avenue, where Baltimore staples such as Holy Free Holies and Golden West and Avenue Kitchen and Bar all offer live entertainment ranging from karaoke to DJs to live bands. And I'll also note that all 3 of those locations are actually located in the less intensive C1 zoning district, and they also abut residential zoning districts. The proposed acoustic music during dinner time and the live bands and DJs for private events only, no public shows, is actually less intense than those public live entertainment uses that I previously mentioned, including live band shows, karaoke's, DJs, etc., for public invitation. The applicant is also, as I've mentioned, familiar with the Baltimore City noise ordinance and is going to perform soundproofing necessary to comply with those requirements. The property's location adjacent to single-family dwellings, the Icon apartment building, and the Hampton Elementary School is consistent with the character of its underlying C2 community commercial zoning designation, and the existence of schools and dwellings does not give rise to any sort of adverse effect above and beyond what is inherent to the use in the C2 district. It's currently accessible for emergency vehicles. The use is not going to impact light and air to the premises or the property in the vicinity. The proposed accessory live entertainment does not require facilities beyond those that will serve the by right restaurant operation. The live entertainment is not going to impact any sort of cultural or historic landmarks. The Hamden neighborhood is one of Baltimore City's dining and entertainment destinations, and the property is located in the Rotunda, which has been non-residential in its character for over 100 years. So the community-oriented use is consistent with the C2 district. The proposed use also furthers both the earn and the live elements of the master plan, as it will add 75 new jobs, 8 of which are actually going to be salaried, and it's also going to provide a walkable dine-in restaurant with the acoustic music during dinner. And I do also want to quickly note, it is not listed in your exhibits because they came in during this hearing, but there are 2 letters in support of this application from residents. And I believe a few more may be filtering in, but these are residents of the Hamden community who, like many residents in Baltimore City, are not members of their community association, but do look forward to the addition of live entertainment in their neighborhood. The project is not located in an urban renewal area, and the restaurant use is permitted by right. No further zoning relief is requested. Turning to the statement and intent, the intent and purpose of the code, it does not run contrary to any of the 8 purposes, and actually supports, as I mentioned, the city's master plan. We addressed the fact that it supports both the earn and the live elements. It will protect and promote public health and welfare by providing a walkable amenity in the city, a $4 million capital investment in the city, and the rehabilitation of a currently vacant structure. And the 75 new jobs will also promote the growth of the Baltimore City employment base. This applicant is an established restaurateur. Mr. King has experience operating identical concepts at 2 other locations where, as I mentioned, he has not received any complaints at all, especially not in relation to the live entertainment. And Mr. King's commitment to operating in a manner that is consistent with the community and as a good neighbor it's consistent with the 22 other restaurants that he's opened over the past 25 years. I'm turning now to the 4 factors that the board is required to consider. The establishment, location, construction, maintenance, or operation of this use would not be detrimental to or endanger the public health, security, general welfare, or morals. The applicant has met with the community. I believe we will hear from community members later today, and recognizes the wariness of residents in such situations. The majority of the concerns raised, delivery hours, parking, staff loitering, construction, and residential infrastructure, are associated with the by right restaurant use and are in no way related to the requested accessory live entertainment approval. The applicant has also offered thoughtful, concrete plans to ensure any noise associated with the proposed live entertainment will not be disruptive to nearby residents. The city, as I mentioned, also has a noise ordinance that regulates the permitted decibel levels of commercial uses adjacent to residential districts. And if the barn and lodge does not comply with the ordinance, then it will be subject to the code enforcement proceedings, providing yet another safeguard for residents. The property is not located in an urban renewal area, and I will not repeat what I have already said and read from my testimony, but the authorization is not contrary to the public interest for the reasons discussed both in my written and oral testimony. And specifically, it will facilitate the creation of 75 new employment opportunities, and 8 of which will be salaried, and an over $4 million investment in the city, and the authorization, as discussed previously, is in harmony with the purpose and intent of the code. So for the reasons set forth above, we respectfully request that the board approve this application for conditional use approval for accessory live entertainment. I again understand that there are members of the community here who would wish to testify. I do simply wish that we reserve time for us to respond to that testimony. And I also request that members of the community confirm their residency in Hamden at the start of their testimony.
Can I ask a few questions before we turn?
Yes, of course.
And this goes to some of the issues that have been raised by the opposition,
Yeah.
particularly in the letter of Councilman Ramos. You've talked about the, at least the proposal or the request for daily valet parking or every day that it's open. You indicated that's effectively cost prohibitive. It's very expensive. It's not an expense that really the restaurant or the establishment.
Yes, and I think I would also like to add, we are not requesting an off-street parking variance. And we are more than happy to work with the community and be supportive and be a good operator. But this application is for live entertainment, which doesn't have a parking requirement under the code.
Okay. But you've indicated that the applicant would consider or is intending valet on weekends?
Yes, so that is the intention, Fridays and Saturday nights, and also large special events.
Okay. The restaurant will be open on Sundays as well?
Mm-hmm.
Apparently there was a request to leaving the original brick on the facade.
That's not related to live entertainment.
Yeah, no, it's not. Other request, parking. On the testing that you would do for the sound and the, I guess, decibel levels, would that be recurring testing or sort of establish sort of a baseline?
Yes, so that would be to establish a baseline, although Mr. King has already provided his contact information specifically to some of the residents who live along Elm Avenue. And the general manager will also provide their information so that residents can call if there are any issues. But this is baseline testing. The plan is essentially to stick a band in the space, go do the sound testing, figure out what the levels are, and then perform any supplemental soundproofing necessary to make sure that we are within the parameters of the Baltimore City noise ordinance. And the noise ordinance, I have reviewed it, does not allow anything beyond what would be reasonable for somebody who is living in a residential home and it's 9 p.m. on a weeknight.
Okay. All right. Thank you. Any questions for the applicant at this time?
Just one quick one. Thing that I thought was a recurring concern about not wanting to meet with the neighborhood organizations. Did it take a while to pull that together?
Yeah, I'm not sure entirely where that is coming from. I think the application was initially submitted, and as I mentioned in the beginning, it was submitted without reaching out to the community because it's in this Rotunda shopping center, and so it's a shopping center. There's already live entertainment, and it is frankly mea culpa. I should have reached out. I now look at it and I see the residents on Elm Avenue, and I recognize that. But as soon as I believe the councilwoman reached out to us in May and requested that we meet, and we immediately agreed to meet. The Hamden Community Council, we reached out to them and shared our plans at the same time that we met with the kind of group of individual residents that the councilwoman organized for us. And then we went ahead and presented at the Hamden Community Council, and I have the correspondences here. They're not in the file, but I brought them for my reference, and I'm happy to share. We reached out and said, please let us know if there is any other additional information that we can provide. And did not receive any follow-up, but did receive the letter of opposition. And would have been happy to continue to engage had we received additional feedback.
Another just to mention that this was previously scheduled and then postponed. So many of the we didn't separate the letters into letters from June versus more recent letters. So some of the letters were submitted in June before that initial hearing that was then postponed to meet with the community. So there, things may have changed in the interim, but it's all part of the file. So you might want to just check the date that the letters were submitted.
And the initial hearing was scheduled for June 18th.
Good. Okay, thank you. We'll turn to the opposition. Of course, you'll get the final word, and you can put on your rebuttal testimony to the extent you'd like. But we'll hear from the opposition. We can start with Councilwoman Ramos.
Even if I sit down, I'm going to be short, so I'm going to just stand by the podium. It's okay.
Feel free.
Thank you, Mr. Chair and Board. I've said it all in my testimony. We do have neighbors here who've waited most of the day, so I do want to yield to them as well. I do want to appreciate Barnes & Lodge and their representation for meeting with us as soon as I reached out. Obviously, they've also worked with me for many years, well, 4 that I've been in the council, and know that if something's in my district, you should come to me first. And so I think that's where that sentiment ends up coming from, because the neighbors weren't informed until we saw the sign. Well, they saw the sign. I live further away. I am so proud to represent the Rotunda area. Many of you have been there. It is a wonderful place that has a lot of shops, the grocery store. Lots of people come there from all over the city to enjoy those amenities. So it is also home to over 400 residents. There are apartments in that space, which again, I'm glad that they're there. And we do have testimony from a couple of those residents about, nobody's reached out to them about the live entertainment on the plaza. Many of them enjoy it, which is a good thing. I think it's great. But I also know that it can be, there's a testimony from one of the residents who had to move her apartment, who had to move to a different part of the apartments. And I do not yet have confirmation as to if there's a special event permit for that live entertainment or not for those concerts. But I will say that there's a lot of people that come, and as a result, there is a parking garage on the other side. So when you first come in, you pass the Moms, you go past the Xfinity, you go around, you go to the Cinnabon, you go to the, Pure Raw Juice. I mean, I do that too. And but there is a parking garage behind that, which a lot of the residents do park in, because there's residential permit parking on Elm Avenue and on 38th Street. So that has been taken care of early on. And the concern is that, and they do provide, that parking does provide, 4 hours of, 2 hours or 4 hours of free parking for anybody who's in the Rotunda area. I don't know of anybody that goes shopping at the Moms and takes their grocery cart up to that parking garage, because the grocery carts don't fit in there. And so when you think about having additional traffic coming in without the valet, because the valet could certainly use that parking garage. So just, trying to think of ways that, some of these things can be accommodated if we have the things that the community has asked for. I do appreciate that the applicant was willing to have conditions as well. And, I think that there's further conversation that can be had, but you'll hear from residents that they're extremely concerned about the bait and switch that it seemed like there was when we first met with them about the happy hour being 7 p.m. and then them coming back to us in an email saying, oh, no, wait, it'll be 8 p.m. There's, about amplified music, I think that's kind of where some of this comes from. And again, you'll hear from the residents. So I'm really excited that Barnes & Lodge, and really any business, wants to come to Baltimore. But I also know that, the 400 residents in the Rotunda we want to make sure that they can live there, and then the residents on Elm Avenue as well. So again, I'm very proud to represent the area. I think they're doing very well. I would just want to make sure that there's some of these accommodations in order to make this work. My letter's in opposition asking your help, Mr. Chair and the board, so that we can make sure that those conditions are done with your guidance and oversight. Thank you.
Okay. Well, thank you, Councilwoman. Couple of questions regarding the space in which the restaurant is going to occupy. Have there been? I'm just curious. Have there been other opportunities or efforts to fill that space since it's been vacant?
I'm going to answer this question by going back in history a little bit. As the applicant was saying, or the applicant representation was saying that, this was initially that beautiful, rotunda building with the giant and an enormous parking lot. And so I think we all remember that. And so with a lot of, and this was before my becoming a council person, but I was aware of the situation, a lot of negotiating with the owner at the time. And actually there was going to be condos there, and there was a whole nother, design. And then of course, in 2008, the economy tanked, and it took them a while to get this up and running again. And so it has since changed hands. It is a new owner. And so I have reached out to the head of the company because I did not do that when they first changed hands. So that's on me, obviously, to just have that relationship so that when there are, new businesses coming in, that, we avoid this problem again. So that particular space, it's my understanding, and the residents can correct me if I'm wrong, that space has not been programmed yet from the development. And it may have been office space at one point in time. And so, but it is still there, and one of the things that still needs to be programmed.
And just from, may I add just quickly, from my sort of historic research that I've seen, it's been advertised as a restaurant space for several years.
And the residents can correct us because they, right there on Elm Avenue, have been there.
Got it. Okay. Okay. That answers the question to that. Because I'm trying to focus on live entertainment here, and obviously, which is what we're here for.
May I, Mr. Chair, say that the live entertainment itself obviously has impacts, right? In terms of more people will be coming into the space. And so that's the other thing to factor to consider.
Well, what do you mean by that? Yeah, there'll be people coming in. It being occupied by anything or any service, whether it's a restaurant or something else, would invite more people.
I don't think anybody's opposed to the restaurant use.
Right. In terms of the live entertainment drawing more people, is that what you're suggesting? I think hopefully from the restaurant standpoint.
Well, I think the concern is also the restaurant, the event space. So one of the things we talked about with an event space, let's say they have a wedding, right? And hopefully there would be, thank you. Hopefully there would be a, Mr. Chair, I don't think you have your mic on. So, that's over there. Some of the residents couldn't hear, sorry. So that, if there is a wedding, let's say, right, it's a 100-people wedding, hopefully they would come in vans, like some do, from a church into the vans or wherever they have the wedding for the reception. That may not always be the case if it's a different type of event. So I think that's part of the consternation is really about what does that look like. I think a regular, restaurant use is different than the event space. And so I think there's some concern there as well.
Any additional questions for the councilwoman?
Okay, thank you so much.
Come on up.
Hi. I do have some things, if I
Your
may.
name?
Yes, absolutely. Shana Roth Gormley.
Spell
Shana ROT as in Tom, H-GOR-M as in Mary, LEY. And I am going to pass these around. Thank you so much.
The folder. Yeah, it's run through it, it should be.
All right. Thank you very much for the opportunity to speak. Again, my name is Shana. I am an attorney at Community Law Center here on behalf of the Hamden Community Council and the residents that you will hear from shortly. We are opposing the request for live entertainment for this location for a number of reasons. The first is the urban environment and the close proximity right across Elm Avenue of a dense residential neighborhood zoned R7 and R8. So this is to the conditional use approval standards. This really relates directly to some of those factors that the board will need to consider. So it is the nature of the proposed site, the nature of the surrounding area, the proximity of the dwellings. So the line, the zoning line from between C2 and R7, R8 is Elm Avenue. So right across the street is where that zoning changes. So it's directly across the street from these residential row homes. It's the closest building in the Rotunda complex to these residents on Elm. Elm Avenue is a quiet street with one lane of traffic in each direction and parking on both sides of the street. There are many longtime residents, and you'll hear from those folks shortly. They're not opposed to businesses in general, and they patronize businesses in the Rotunda and elsewhere in the neighborhood. But they are concerned that if live entertainment is permitted, this is going to become an event space, not just a restaurant that's permitted, but an event space with significant noise, with late hours right across the street from their homes, which have their primary bedrooms on the street side of Elm, and they face directly into the venue space. So, and the proposed large windows that you'll see in the renderings are facing directly into those residents' primary bedrooms. So this would be a major burden on the immediate neighbors, and the live entertainment, in addition to the noise, is also, as the councilwoman said, going to pose those logistical and physical issues with more people coming in for those live entertainment events, those weddings and other big events in the space. So the first document that I gave you is a community site analysis, and you can see there the proximity of, yes, the homes to again, this space is the closest to those residential homes of any of the buildings in the Rotunda. What you may not be able to see there, but I think becomes evident when you attend the Rotunda Rocks event or when you go just to the Rotunda, is the way that noise bounces around. So because there are all of those buildings and that concrete stairway that I think you see on page 7 of the community site analysis, the sound really carries and really travels and is amplified by the space itself. So as the councilwoman mentioned, already one resident of the Icon apartment building has moved to a different part of that building to get away from the noise that is already happening during the Rotunda Rocks events. So the concerns are about both indoor and outdoor live entertainment. As you can see on page 9 of the community site analysis, the patio on the left for the outdoor space would mean that people would be leaving in the direction of the homes on Elm. And then there is a patio bar that we saw listed on the renderings and the site map that we had initially received from the applicant. I do want to address the point about Schultz v. Pritz and the standard there. So the standard about this particular use proposed in this particular location having adverse effects above and beyond those inherently associated with a conditional use of live entertainment. I think you will really see that here because already the Rotunda Rocks event has those serious adverse effects on the community. We have small children who, their bedtime is 8 or 9 p.m. They're already staying up there because of that. But that's only, I think, 20 or 30 nights a year. What we're talking about here is potentially every night there would be live entertainment, there would be large events much more frequently than what we're already seeing. So that is an adverse effect above and beyond. And so let me talk some more about some of those concerns that come along with the live entertainment. So infrastructure, including where loading and unloading will happen, trash, parking, utilities. So I think one of the big concerns is that the applicant doesn't necessarily understand the space and how this urban location differs from some of their other locations in more suburban areas. So at that meeting in June, the initial meeting, the applicant mentioned a loading dock, but there's no loading dock really adjacent to the restaurant building. There is one for the Icon Apartments down the street. You'll see on page 7 of that site analysis kind of how the facing Elm Avenue towards the rotunda, how things are structured. So and I also want to point you to this was actually from the applicant's materials, the plat map with the outline in red. So you can see on, if you kind of turn it this way, you'll see Elm Avenue here. And right kind of midway through is a small space here labeled boiler room. So that is to the question about what this space has been, what it was initially. This is from, I think, 1929. And the initial use of this building was as a boiler room. It has been, as far as we can tell, vacant since then. You'll hear from some of the residents that there have been birds nesting in that building that they can actually hear from inside their homes. They could hear the birds. But this was a boiler room space. It hasn't, it was renovated to be an office, but I don't know that it actually, or a Bank of America, I don't know that it was actually opened for that use. But that was its initial purpose as a boiler room. It wasn't really intended initially even as an office, much less a large live event space.
In 1929?
This was the initial building, yeah.
Well, what do you think the purpose was in 1929?
Boiler room, yeah.
For that time.
Right.
So.
Right, and then since then, it hasn't had a use, as a boiler room or otherwise for some time. And so I think that, and perhaps that does show that they put the boiler room kind of in that space towards the residents, knowing that this is kind of the more residential side. We're going to put the larger uses, the uses that I think are going to have more of an impact towards the center. And that is how the rotunda is designed now, that the more bustling effects are more towards the center. Along the edges, you've got the residential, and so you're kind of moving away from the commercial towards the edges. So I did also want to bring up the suburban locations of some of the applicants' other businesses. They are, as the applicant's attorney said, they are near some residential homes, but they are not near the dense row house urban neighborhood that is truly right across the street. There's 2 lanes of traffic, 2 parking lanes on Elm. And so this is a really different character of an event venue that is really against the public interest for Baltimore City and for this neighborhood. So already there's concerns about, where is loading and unloading going to happen? That the space there for the Icon is not abutting the restaurant. Is that going to happen on Elm? Is trash going to get picked up on Elm? Is valet parking going to happen on Elm? There's not really space for all of those things. And those are, again, right across from and right next to the residential homes. One issue that a number of residents have mentioned is there have been several recent sewer backups in the area. And so there's already, I think, a high burden on the neighborhood on the sewer lines and that infrastructure. And there are concerns that with a nearly 300-person seat venue, there will be more people coming in for those live entertainment events to this venue, causing even more sewer issues. I also want to, I'm sorry.
What is the, is that a recurring problem presently?
It has been at least several times in the past few years, from what I understand. And I hope that the residents can also point to that when they have their testimony. So, yes, I mean, I think that the full 300-person, maximum head count, that's not all for the restaurant. Some of that is for the event space. And so the live entertainment in those, in that live event, or in that event space is going to be a draw. That is bringing people in and is adding a burden to the infrastructure in the area, whether that's parking, whether that's the sewer, the use of the valet, the additional trash, and all of the things that go along with the space. All of that is amplified by having live entertainment. I also want to point to the inadequacy of the application itself. We, in the materials that we had previously received, the site plan didn't show the location of the restaurant within its surroundings in the rotunda. It didn't show, where is North, where is Elm, where the loading and unloading will happen, where trash will be located, what the traffic pattern will be for drop-offs, what the plan is for valet parking. One of the renderings submitted had Blackwall Barn and Lodge on the TV screen, so showing that it was from one of the other locations and not really, for this specific location itself. And so I think all of that, as it relates to live entertainment, it makes it difficult for the community to know how can we fully, communicate with and comment on this proposal without knowing some of that information. So the applicant called live entertainment as a conditional use consistent with the character of the community. I don't know that I agree with that. I think the fact that the current live entertainment in the Rotunda Rocks event Friday nights in the summer, goes until 9 p.m. So that's really only rarely. There is a farmer's market on Tuesdays. But those are seasonal. They end by 9 p.m. This would be much more frequent than what currently exists there. And most of the other businesses in the Rotunda close by 9 p.m. or earlier. I also want to point to the lack of transparency and true engagement from the applicant with the community. As they pointed out, there was an initial, they initially had not reached out to the community. The councilwoman recommended that they do that, which they did, which the neighborhood appreciated and did want that opportunity to have a conversation. As they mentioned, some of the things that felt like they were promised or expressed at that initial meeting immediately changed, which really, I think, set the tone for the community in a negative way. They were told acoustic music, and then they learned that that was amplified acoustic. I think, for most people, that is the general understanding of acoustic is in opposition to amplified. They were told the outdoor music would stop at 7 p.m. The next day that changed to 8 p.m. They had initially...
Question.
Yes.
If the decibel level of the live entertainment is within acceptable Baltimore City code and ordinances, is it still a problem for the community?
So, I think the question there would be, how will they be conducting that test? So is it going to be under the conditions of what the live entertainment will actually be? Is it going to be with a full band, with a room full of, wedding guests who are also talking and dancing and, lots of other stuff is happening there as well. Where will they be testing it? Will it be, where the neighbors are? Or will it be, if they're doing it on the zoning line, that would be in the middle of the street. So, does that necessarily tell you what the neighbor's experience is going to be right across the street or, in the 3900 block versus the 3800 block of Elm? So I think we do have questions about that, and we would certainly want to know more and be able to say, here are our concerns, and would certainly appreciate having those addressed.
Okay.
Yeah.
Suppose testing is done on the resident side of Elm Street
Mm-hmm.
in all the variations that you described,
Mm-hmm.
and that sort of pass the threshold for the maximum decibel level that's allowed in the city.
I mean, I think that would be.
You said that could be done?
I would be surprised if it did. I mean, just knowing how the sound travels there, but I think the residents would really appreciate that if it were done, within or right where their homes are, rather than just outside the building, because I think you would get where you test it. I think is really going to make a significant difference.
But wouldn't you get, if you test, suppose you tested at the restaurant so that they can understand what the acoustics are and what the noise level is at their actual geographic location, is it safe to assume that if they tested it further away near the residence, that the decibel level would actually be lower?
So yeah, I think what I would be concerned about there is the way the sound travels within the rotunda. It does seem to get amplified and bounce off of the other buildings. I've heard some of the, and I'll speak about this in a moment, but some of the materials that you have are petitions from residents of Roland Park Place, which is a senior living community across 41st Street, and they are able to hear the music from the Rotunda Rocks, which is outside, so a different situation there. But the sound does seem to get amplified in different directions. So I think if you were testing it at the Rotunda level, which is slightly above the street level from Elm, I do think you would get different results. And I don't know, what those would be from one to the other.
Oh, well, let me take a step further. Given the example of the folks at the Roland Park Place, is it?
Yes.
They can hear it, but is it in violation of the city ordinances? And what has been the response there?
Yeah, I think that's a fair question, and I don't know that they've called it in. I think in some ways, knowing that you have a seasonal, time-limited, we just have to put up with this on Friday nights, even if it's not our cup of tea, is different than knowing that this venue, this restaurant, is going to be operating every night of the week. And we don't just have to get through it tonight, we might have the same situation tomorrow night. So I think that is a really different situation. And again, I think you can really draw a distinction between the music that's already there and what would be coming or what could be coming with this event venue. I think that is a difference, and I think it's significant under the Schultz v. Pritz standard. This is an adverse effect potentially above and beyond.
Is it adverse if it's legal in terms of the volume and the decibel level? Is that adverse?
I would say it could still be adverse, but I think there is still a question of the decibel level. Is it?
It's always a question of the decibel level.
Absolutely.
And if it's beyond what it's required to be, then you call it in and you
Yes.
pursue that angle. But to the extent you don't call it in, or it's not demonstrated to be illegal or in violation of the ordinances, it's sound that the city in the ordinance has determined is an acceptable level.
Mm-hmm. So a couple things I would say about that. One is, especially for later evening calling in 311 complaints or 911 complaints, 911 you get a response. 311 it can be challenging, especially after hours.
That happens all over the city.
Yes.
Not just there in Elm Street.
Absolutely. But I think that talking about it now before it happens and saying, here are our concerns that we want to get on the record. We know that these are already issues. and amplifying the volume and the knowing the amount of times that they're going to be facing this situation, that is already, I think, a difference between what they're already seeing.
But it's not, it's a, in terms of the frequency, perhaps a difference. You'll hear music more, or there's expected to be a greater frequency of music playing or live entertainment. But in terms of it being violative of any particular ordinances, that hasn't happened. So I think, based on what I've heard thus far, it's been brought to the applicant's attention that that's a concern or it may be a recurring concern. But my point is, you're opposing it before it's happened. There's a mechanism for dealing with it if it does eclipse acceptable levels, just like the Friday night rock bands and whomever hears that and however it travels. But to the extent that this applicant, like any other applicant or any other business or anybody else who's playing live music with authority, they've got to monitor and be mindful that they have to stay within city code. And my only question is, would you still be opposing it if you can't know the future? You're concerned about the future, I get that. But if they're following the law and doing what they're supposed to do and keeping the levels where they're required to be or below, how is that adverse?
So, I mean, as you said, we can't know the future. And so what we're trying to do is say, here is what we're concerned about. And I think the issue here really is that we have concerns about them being a good neighbor. Is it going to take a call every night of the week to keep the music down at the level below where, it's considered, illegal or, too high by the city? I think the fact that we did have to push for these initial meetings with the applicant, that we weren't aware that they had already gotten a liquor license. That was something that, despite these conversations in June and July, we didn't find out until just recently that they got a liquor license in March. That had never come up. I think some of the things that changed in those initial conversations, and I'll also say, in my outreach to the applicant's attorney last week, I had asked if there were any updated materials and was told I would get them today. And I just, as you saw, got them at the beginning of the hearing today.
And that was an accurate statement.
I'm sorry?
And that was an accurate statement.
Yes, right. And so I think the applicant has not demonstrated that they are willing to really work with the community. I think if they were genuinely interested in being a good neighbor, they would have laid everything out on the table for us, and especially when I reached out last week to say, on Tuesday.
But working with the community doesn't mean the community gets everything that it asks for.
No, certainly not. I mean, I think that's how, as the applicant's attorney pointed out, the city's comprehensive master plan talks about a lot of different factors that go into city living. One of those is live and earn and work, and there are a number of others. So how do you balance those factors? And I do think that's why we're here, that these are residents who have lived here, some of them for decades. They're raising families here. They have small children. They work nearby. Just in terms of the financial impact, if you do kind of a rough count on Zillow of the home values along those 2 blocks of Elm that face the rotunda and face the restaurant building, that's $12.9 million worth of home value there. So if you're talking about investment in the city, those are residents who have, put themselves, their families, their finances into the city. And so it's a question of how do you balance the residents and, their desire for a peaceful living environment and, wanting to see business in the community, but also not wanting something that's going to keep their kids up at all hours.
Okay.
Yeah. And so I think, just to wrap up, I do think that all of the things I've talked about and the zoning standards really point against approving this conditional use. The nature of the proposed site in terms of the factors for you all to be looking at, the nature of the proposed site, the concerns about the resulting traffic patterns that are likely to come in as more people are coming and going from this venue, parking and loading issues, the nature of the surrounding area and the proximity of dwellings, just truly feet away from this building. The additional strain it will impose on utilities, particularly the sewer system, all point against approving this conditional use.
Tell me more about the sewer system issue.
Yeah.
You've raised some, I don't know if it's anecdotal, but you said you've understood there are some problems.
Mhm.
I haven't seen any evidence of any problems other than what you're suggesting. I've heard some people talk about some sewer issues. What's the magnitude of it? Have they been fixed? What's the remedy for it?
Yeah.
I mean, this place is designed and has the infrastructure for some activity of some level. The rotunda in and of itself is an attractive place to be. It would seem, for any business to draw patrons.
Yeah, so I would say, from what I understand, there have been several sewer backups over the past few years. And so I think what the residents have been told is that that is just a factor of the strain on the infrastructure. There's just a lot of use of the sewer system in this area. And so that's even without, again, this building has been vacant for a number of years. And so if you're adding in potentially up to, almost 300 people capacity in this space that's been vacant, that is going to be a new burden on the system that hasn't been there yet. And so I think that's what residents are already seeing is this this strain that they now have to deal with, and that they have had a lot of issues in getting the city to assist with, even though they're doing everything they can. They're just one resident within the city system.
Councilwoman, you want to address that issue?
Thank you, Mr. Chair. There were several backups along Union and 38th, which is on the other side. Those have been fixed. I won't go into the gory details, but they have been fixed. And some of the residents will testify about what's happening on Elm, but, obviously, the strain is going to be an issue, and we'll, address it if it comes up from the city's perspective. But the ones on Elm and 38th, Chestnut, and Union have been addressed. And those were pretty massive in terms of they were not wet weather, they were dry weather. It was really bad. And I think part of it was that my understanding is when the rotunda was built, I actually don't think that there was a lot of consideration for how big and massive this development was going to be. So we've addressed that on that side. I would imagine there's some strain also on Elm, although, if it comes up, we'll certainly address it. But I do think that there is, I will tell, that is clear that there has been some stress there on the infrastructure that we've had to address.
Okay. It's good to know that it's been remedied, at least in part.
At least that side. But again, just letting you know that it is something that has occurred.
Okay.
So just to conclude, I do think that while many of the residents support businesses, they patronize the businesses, what is being proposed for this location, live entertainment at a restaurant and an event space like this, might make sense in a suburban setting or even in an urban setting that's not directly across from this really dense neighboring row homes. It would ask these residents to bear the brunt of the externalities that get enjoyed by the whole neighborhood, the city at large, while having to live next to this disruptive live entertainment potentially multiple nights a week. These are residents who enjoy and they choose city living, but that doesn't mean that they should have to bear the loud noises from events facing directly into their bedroom windows late into the night, year-round, many times a week. So for those reasons, we oppose the live entertainment conditional use that's being sought. We do have some letters that are in opposition that are in your file. Along with the community site analysis, I passed around some additional letters, including one from a 10-and-a-half-year-old resident who lives right across the street that she hand wrote and had wanted to send through the mail, but we said, let's make sure to get it directly in your hands. as well as a petition with 74 signatures from residents on Elm Ave, Pleasant Place, which is right behind Elm, and Roland Park Place, the senior living community. And we do have a number of residents who would like to testify as well. So we can have folks come up.
Hold on, any question for
Oh,
council?
okay, yeah.
Yes, I do. I'm going through sort of the criteria in terms of we have to address. I'm curious, do you know how many live entertainment licenses currently exist in the neighborhood?
I am not sure about the neighborhood at large, but I do know that there are some other event venues. I think there are some other event spaces, but that are more kind of, in some of the other locations, more along 36th Street, along the avenue. So that's where you tend to see I don't think there are any that are of this scale, but there are other businesses like along 36th Street.
When you say of this scale, what do you mean?
So I believe the maximum seating capacity is 271 people for this space. So that's, I think, really out of proportion with what else is in the neighborhood, and as well as what's at the rotunda itself. So most of the businesses there are, they're smaller, they're really walkable. This is, I think, as I said, the feeling of a suburban venue that's kind of dropped into this urban location.
I think one of the things that, and where my questions will probably lead throughout the rest of this hearing, is talking about the Schultz standard and talking about an adverse effect above and beyond other businesses or other live entertainment licenses. We'll have to say that, right? And so there are other live entertainment licenses in Hampton. And there are other live entertainment licenses in proximity to residents in Hampton. And so one of the questions that I'm going to continue to seek answers to is the sound that they are proposing is, I think, what I understand it to be is it's going to be, let's just say, for example, a jazz trio seems like the right fit, and they can talk more specifically, or a singer with a microphone and a guitar player or something like that. Sounds like it's different than the rock and the rotunda thing that's already occurring. So what I have to figure out is this going to have more negative impact than the other live entertainment licenses in that residential neighborhood? And so that's the question we're going to have to answer today. So right now, I understand the neighborhood's concern around just what this proposed venue means in a lot of different areas, but because we're looking at the live entertainment license specifically, the board's going to have to narrow their focus there. And so that was sort of my question was, in your mind, based on your conversations with neighbors, of the live entertainment that they have described will be at this location, how is that above and beyond in terms of impact from other live entertainment licenses in the neighborhood?
So I certainly understand that you have this standard, but I think there are a couple of elements to the standard that are worth considering. One is the particular location. So not just Hampton as a whole neighborhood, which is a fairly large and diverse neighborhood in terms of the streets that you have. You've got a strong commercial district on 36th Street. You have Elm and the Rotunda. I would say that's a different beast than 36th Street. You have a quiet set of row homes up until now along Elm, which is different than the folks who live, near or right behind 36th Street. They know we're living on a commercial strip. We know we're living close to venues. We know that there's going to be music. There are bars open late. That's not the situation with Elm, and particularly when many of the neighbors moved in before the renovation in 2013. The Rotunda was an entirely different type of commercial structure. But I think also, so the other part of the standard is the adverse effects above and beyond. And so I think that is really the example you gave, a jazz trio. That's different than, you know, a DJ or a full band playing at a wedding, which is what it sounds like we're likely to see in this space. So I do think that that looking at the standard, there is a distinction here between what's being proposed and what's already existing in Hamden. And I think what the neighbors are, you know, have been used to or even came to the neighborhood for, and that's not the case with this proposed use.
Mr. Chair, if I may, and then I have to leave, I just want to say one thing on this particular issue. Businesses along the avenue, most of them are closing at 10, 11 o'clock, unless it's Christmas time. And you know what happens at Christmas time on the avenue because of the lights down the street. But that's also temporary, but they're closed early. They are not event spaces. They do not have people coming in saying, we're going to have a wedding, we're going to have, et cetera, et cetera. I will also remind the board that you denied last year a live entertainment license for 4001 Falls Road, which is not in the business area, but Falls Road is becoming one. And that was because the live entertainment was just right across the street, and it was going to be both indoor and outdoor. And so it's not out of the question that has occurred here. I think, Commissioner Cornish, you remember that. I think you were there. But I do think that there's a difference here, particularly, not necessarily around the restaurant use, but certainly around the event space use. Thank you. And thank you all. I appreciate it. Thank you.
Thank you, Councilwoman. What else do we have? Any more questions for council? Thank you.
Thank you. Now we've got a few folks, if you want to give your
Sure.
names, address, and, yeah, go ahead. I'm just going to sit back here.
So, what do you need information for me? Yeah, if you can raise your voice, you can go ahead and sit down. I think you were already sworn in, right?
Yes.
Yes.
So how does this work? Is push
You're good. Is it green?
No. Yes?
Yes.
Yes.
So, if you can just state your full name.
Yes, it's Blaise, Blaise, Ahern, Ahearn.
Before you get started, regarding that last piece of information from Councilwoman Ramos, a denial for live entertainment in Falls Road, you're calling
That
it?
was when I first started, so I would say that's 2.5 years ago. I was just looking that one up because I was feeling kind of fuzzy on that case.
I was here, so I'm sure voted on it, so.
You were not. No, the only person would have been James, who was on the board. And it was a long time ago, and I don't remember it clearly, so I was just looking it up. So I can fill you in a second.
Great, thanks. Go ahead, sir, sorry.
Sure. So my name is Blaise Ahern, and I am an executive board member of the Hamden Community Council. The reason we're here today is for conditional use exception to the current zoning code. The neighborhood residents do not want an exception made to the current zone, nor does the neighborhood association, nor does our city council representative. Titan Hospitality Group has a lease agreement with the Rotunda to build a restaurant at 729 West 40th Street, and by right can build the restaurant in that space. But the current zoning does not allow for live music and entertainment.
I'm sorry, sir, I'm going to ask you to keep your voice up a little bit.
Sure, sorry. The Rotunda is a residence to many and a grocery store, a gym, a nail studio, a coffee house, a movie theater, and several small eateries. Suffice to say, it is not an area known for its nightlife. The Barn and Lodge location within the Rotunda abuts Elm Avenue, a street of row homes with primary bedrooms and living quarters, most often facing the street. Suite 101 sits on Elm Avenue and has a glass wall facing the residents that are nearly just 50 feet away. Hardly any insulation or limiting factors to provide for any privacy. The neighborhood residents do not wish to have live music and entertainment entering their homes and bedrooms at any hour, much less until 1 a.m. or later. The summer concert series Rotunda Rocks is 1 day a week, 5 months out of the year, and until 9 p.m. It accounts for 6% of all days of the year. This is troublesome enough for these residents, and they do not wish to increase this headache 60-fold by allowing live music 365 days a year, and certainly not specifically into the early morning hours. As I'm sure you're well aware, Baltimore is a city of neighborhoods. From the live music scenes of Fells Point to the shopping of Harbor East, the arts of Station North, or the nightlife of Federal Hill, the Victorian homes of Volin Park, or the Orioles faithful in Ridgely Delight, Hamden, too, is one of the neighborhoods of this city, known for its tightly packed old miners' houses, now owned and cared for by an eclectic and somewhat eccentric community. In the last 25 years, the Hamden community has generally been agreeable to new developments, new restaurants, new businesses, new revenue opportunities for the community and the city, but one sticking point has always been live entertainment. Hamden is a family-oriented community, and its neighbors know each other very well. Many of us have shared walls. Throughout the neighborhood, none of the new developments, restaurants, or establishments built over the years is known for or labeled as a place to see live music and entertainment. And that's the way the neighborhood wants it to be. Generally, when a new business is interested in investing into the community, the first action they would take would be to introduce themselves to the residents, knock on some doors, shake some hands, and have a conversation or two about what you are offering, or perhaps listen to what residents say might be needed. I know that whenever someone moves into a new neighborhood, one of the first things you do is you try to meet your neighbors, try to find some common ground, and perhaps make a friend or two in the process. Actions speak louder than words. It was only after significant urging by our city council representative that Titan Hospitality agreed to meet with the residents prior to the original BMZA hearing. There were 2 meetings, one with the residents directly and one at a regularly scheduled Hamden Community Council meeting. Outside of these 2 occurrences, I do not believe representatives from Titan Hospitality have gone out of their way to meet with or talk with any of their new neighbors. Frankly, I ask, how many doors have you knocked on? How many conversations have you had with residents? How many neighbors have signed a petition of endorsement? If they truly wanted to invest in the community and the city, wouldn't they have been proactive about introducing themselves and their goals to their new neighborhood? I find it odd that the onus is always placed on the residents of a community to prove that a new addition is unnecessary or would potentially cause undue stress or harm to their way of life. I think that instead, the onus should fall on the business to prove that they would be a value add to the community, and that gathering support from the neighborhood should be a requirement of consideration for approval by the zoning board.
Well, sir, you know we have standards that are established by law, so they may not be consistent with your view of what we should do.
Sure. Following the regularly scheduled Hamden Community Council meeting, members of the HCC board, the Hamden Community Council, met with the residents of Elm Avenue, 38th Street, and the Icon residents directly, alongside Representative Ramos. The meeting was used to discuss the options moving forward. 1, support Titan's application. 2, discuss limitations to Titan's application with a possible MOU. 3, oppose Titan's application. After an extensive discussion with the residents, they were handed ballots. There were 0 votes to fully support Titan's application and 50% more votes to fully oppose the application than to entertain MOU discussions. No one is arguing that Titan should not be able to open their restaurant in the space and that they cannot provide all of the uplifting jobs and revenue incentives to the city and the neighborhood that they tout. Many, many other restaurants in the Hamden community already exist and also provide increased standards of living for the community residents. None operate as live music venues. We look forward to Titan's future success at the Rotunda without live entertainment.
Do you know why no others operate without live music venues?
Because neighbors don't like it.
Are you sure about that?
Many of the neighbors that I've spoken with, yes, have huge issues with live entertainment. I know that Golden West used to have bands, and then they got so many complaints from neighbors they don't have bands anymore. I think Bluebird has some acoustic music on Saturdays.
Did you query any of the residents who live in the apartments in the Rotunda?
We asked the residents, yes. Some of them came down.
Everybody said they don't want it.
We had 50% more votes for no than to yes with limitations, and no one voted for yes.
And you're talking about this is the membership of the Hamden?
Not just membership.
Okay, so
There's
tell
open-
me again the parameter, like, when you're saying the residents, how many?
It was.
How many were involved in that vote?
35 at the vote.
So 35 people voted?
Mm-hmm.
Okay.
And how many people live there?
I think there's like 8,000 people in the neighborhood.
Okay.
At the community board meeting, I think with Zoom as well, there was 75 people that came and engaged. I mean,
What percentage of the folks who live in the apartments in Rotunda are a member of your organization?
I do not know.
Of the 35 people there, how many of those of the 35 people there, how many live on Elm?
I don't know, probably 2/3 maybe?
Okay, that would be helpful to know.
Go back and check.
Okay, well then when you come up, that'll be a great question to answer, because I think the thing that I'm trying to seek out as I'm looking through sort of the live entertainment conditions that we could apply, understanding how many homes are currently on Elm Avenue. Of those homes, how many have either were a part of the vote or have signed the petition, wrote letters of opposition? That would be helpful. So, it's like yes, no, or never heard from them kind of thing would probably be helpful. Thanks.
Nicole Saddlemeyer. Nicole Saddlemeyer, spelled Nikole. Last name is Satel as in Larry, Majer.
I'm just going to make a comment, and it's not a reflection on what I've heard at all. It's something I usually make when we have a lot of testimony, and it's simply that folks not repeat the testimony of other folks, on the points, if it's similar points we get. That's the only issue.
It's been a long day. I'll try to keep it brief and useful information. So
We want to have your testimony from your perspective, but just not the repetition. Thank you.
So my name is Nicole Saddlemeyer. I live at 3900 Elm Avenue, which is directly across from the Rotunda stairs and across from the venue in question. I've lived in this townhome for 15 years. My immediate neighbors on that block, some of them have lived there for 36 years, 28 years, 16 years. One neighbor's grandparents bought an original home when it was first built on 3900 block when it was constructed in 1954. I had all of those neighbors sign petitions, and they are on record. They couldn't come because they were working. But I pick up their mail, I water their plants, like we know each other very well. One of these is Mary Otterbein, who lives directly across from the venue. If you look at those 3 pictures from the windows, the bedroom windows, the one with the lace curtain, that's Mary's bedroom window. It's 73 feet from her actual house to the proposed venue with the large glass windows, and also part of the ceiling and roof is glass also. So when I bought it originally 15 years ago, as many people have noted it was a large parking lot. Before I give some of my comments that will not be repetitive, I just wanted to answer some questions that had come up that I have information on.
Great.
So sewage backups. I bought the house in 2009 when with Live Baltimore, I got like a $1,000 grant, I think, from the city, and I bought the house on my small social work salary. And when I moved in, within less than 6 months, there was a 2-foot sewage backup in my basement. The city took 8 hours to show up. The only reason my basement was saved and only 2 feet of it was immersed in raw sewage was because a plumber came and parked in the alley between me and my neighbor and basically pumped it out, unfortunately, into the sewage drain outside the properties. That saved my house, basically. That was the first one. The next one was, I believe, in 2015. That also was not 2 feet, it was maybe 1 feet. I did have insurance, obviously. The city, although I filled out the paperwork, did not give me any reimbursement for the deductible that I had to pay. There have been a couple recent sewage backups. Some of my neighbors can mention it. For some weird random reason, my house didn't experience it, thankfully. Whenever the gentlemen come from the south, the city hires them to come up, some company to snake the lines. I always go out and talk to them. And they have told me that these sewage lines should be snaked every 6 months, but they said the city only calls them every few years. So I've made Councilwoman Ramos aware of that. So she's aware that although there can be laws and practices in places, the implementation sometimes is unfortunately not ideal. So that's regarding the sewage backup. Regarding the number of homes, there are, is it 35 or 45? I think 45 houses that border from 40th Street all the way down to the end of the Icon block. I flyered every single property twice. I flyered it back in June when we first met with people and discussed things. And then I did a most recent flyering a week ago. I gave them all the information. I tried to keep it neutral and said, these are opportunities to have a discussion. If you're opposed, this is what you can do. There's also a small Facebook group called Rotunda Neighbors, Pleasant Place Neighbors, and it's just informational. Like, it's not gossipy. It's just like, hey, move your car, you're gonna get towed. So we've always placed all the information regarding these ordinances and all this stuff on that Facebook group also, so people at the Icon could also see it there. I've talked with some people that are neighbors at the Icon over the past few months. I tried to reach out to a couple of people recently. Councilwoman Ramos had an email. That was the one person who wrote a letter. And unfortunately, I was not able to reach out to more. There's no community board where I could put a flyer up within the Icon. I spoke primarily with Elm Avenue residents, although Pleasant Place Alley also was interested. I also sometimes talk to people at the elder apartments on 38 Roland and 39 Roland, because sometimes our neighbors from Elm Avenue end up moving into apartments later when they get older. And they have also communicated, like everyone else says, that they can hear the Friday night live music and they find it disturbing. So I just wanted to answer those kind of quick questions that had come up.
Let me ask you, what's the response to them finding the music disturbing on Friday night?
So I think all of us kind of try to say, like, roll with it because it's once a week and it's only during the warm months. So the trees have lots of leaves and kind of helps a little bit with the noise. So, we just kind of put up with it. And also, I mean, we use 311 when we need to. We try to not use it like too often. We can even hear Hopkins University when they have events. We can sometimes hear the mic or the music kind of coming over, that area. So, it's city living. You have to put up with some things occasionally. I think that our largest concern was the possibility of it being possibly multiple nights during the week, during the work week especially, right? When you got to get up for work the next morning. Hampton Elementary starts at 7:30 in the morning. So many of us that have kids, we have to get up at 6:30. And so going to bed early, getting your sleep is important. So I wrote a letter in opposition in June. There was mention of other letters written. Everyone that I know that wrote a letter did not change their opinion. I myself have also not changed it. I've only strengthened my opinion, which is that having a late night venue with live music directly across from my bedroom would destroy the peaceful nights that our neighborhood currently has. It would disrupt our sleep, harm our health and well-being. My bedroom window faces the street. I can already hear a conversation of people pause on the rotunda steps as they exit the plaza. I hear cars honking above at the crowded parking lot. I hear children laughing while playing at the splash pad. These noises are part of daytime city sounds, daytime. And the majority are lovely reminders of the great city that we live in. And occasionally, once a year, there'll be a giant bounce house directly where they're gonna do the patio. And you hear it all day long. It's okay, it's during the day. Or they had some mermaids in a tank. Like, it's part of city living. I like living by the rotunda. I like all the different events that happen. But the concerts that happen, the farmers market and the Friday night venue, they take place about 100 feet further back from our houses than the venue that's proposed. This property is literally right on Elm Avenue. When I first saw the signs, I was like, why would I care about what's happening all the way up on 40th Street? But it's not. It's like literally on Elm Avenue. What would our quiet residential block of the city look like if the Barn and Lodge is permitted to have live music outside and inside? This empty brick structure is the only building, again, that sits right on Elm, and there are massive glass windows. And we would hear weddings and birthday parties, people giving toasts, laughing, speeches, loud amplified music until 1 a.m. apparently. And this event space would be, it sounds like, directly by those large windows. No other businesses in the Rotunda are open that late. Everybody goes to Mod Pizza, everybody goes to all these different places, but by the time we're going to sleep, we don't have to worry about any of that stuff. The building has basically been empty for about 100 years, except for being used as a facility for some sort of boiler, sounds like. It was renovated in 2022, which we heard the noise from, but it was never occupied. I talked to all the surveyors that were involved. It was supposed to be Bank of America offices. Going from nothing to a restaurant of 271 patrons with live music is putting a significant load, noise-wise, on our community. The standards for approving this type of variance ask whether it's contrary to public interest. We personally think the answer is a resounding yes. There are concerns around noise, around parking congestion. Rotunda Plaza already is full of traffic jams. And the Elm Avenue parking gets crowded in the evening. Safety concerns from potential security incidences that spill out into the street, safety concerns from additional drivers on our street after drinking, and health concerns from adding to the sewage system that's already under strain, as I stated. Elm Avenue is a quiet, tree-lined road where I and many of my elderly neighbors can make slow three-point turns with our cars. My child can cross the street relatively safely by herself. My husband and I can safely ride our bikes south on Elm to the Jones Falls Bike Trail. It's a beautiful, quiet street. My neighbors and I look out for each other's well-being, a sort of mini village. We look out for each other. We live in this city. We work in this city. We play in this city. Our kid walks to the local public school every morning. School starts at 7:30. I work for a city program that helps older city homeowners on fixed incomes get free home repairs with stair lifts, roofs, and heating systems. I work in zip codes 212 and 7 all the way up to Parkville. At the end of my workday, I volunteer with the neighborhood public schools nonprofit. I keep up the school's playground, and I raise extra money for the school's teachers and staff. The entire city needs residents to contribute, and that is what I and all of my neighbors work to do every day. We work to lift our city up and support it. We love supporting our neighborhood businesses. We shop and eat on the Avenue or at the Rotunda. My father's 80th birthday party was this summer, and we had a restaurant on the Avenue cater it. I want to make it clear we're not against a restaurant, but we are against a restaurant on this scale with live entertainment, a liquor license, and a late night hours. Please, we need your help to ensure our community welfare is preserved. Thank you for taking time to listen to me and my neighbors and about our important concerns regarding this variance. I'm also happy to answer any other specific questions about this.
Thank you.
Okay,
Any
thank you.
questions for the witness?
No.
Thanks so much.
Hi, my name is Vicki Keller, Vicki-Keller, and I will try not to repeat too much. I am a resident at 3838 Elm Avenue, which is directly across the stairs and 2 houses down from Nicole. And I want to say that I moved into this house in July 2023, so just over a year ago, September 12th. My basement flooded. I was up to my knees in sewage, raw sewage in my basement. I had, fortunately, a floor pump that I could put down and was pumping stuff out, again, back into the sewer, so it's sort of a circular thing.
What was your understanding of the cause of that event?
The cause, when DPW came out to first look at the line and then to snake it, it was a backup of, I mean, I don't want to say it was all disposable wipes, whatever, but there was something that was in the main line. And the cover for that drain, the access to the drain is in front of my house as well. And so they had pumped it out So there in September, November, we got flooded again. At that point, I'd put in some water sensors, so I knew immediately that the water was coming up, so we were able to mitigate that. And that is when the company that Nicole mentioned from out of town came and did a full cleaning down the entire part of Elm, and that was in, I'd say, November.
Was there any portion of this cleanup that the city took responsibility for?
Took responsibility for it? No. When I filed for the damages for September 12th, they said it was like an act of nature sort of situation, and that they didn't see that they were liable for that.
Okay, so do you have any basis to believe that what's happening at the shopping center and any use or impact on sewage systems somehow caused that to occur?
I mean, I am not an expert. I was only talking to people. Now, the rotunda is on an incline above me. Then we've got, the residences along 40th. There's a few apartment complexes, and that's an incline coming down. So again, when I was talking to the DPW work crew, they were pointing those out, pointing out that I was dumb to buy a house at this point where there's, I don't have confirmation that the rotunda, I don't know where their sewage goes. I had heard that it was supposed to have been designed and go out towards, Chestnut, as Councilwoman Ramos was mentioning, that area. But I don't know where to find plans to get confirmation of that.
Okay.
But again, it's an anecdote on one person. I have video and lots of pictures. I don't want to reiterate a lot of points, but what I do want to say is that I am opposed, again, not to the restaurant, but to the accessory live entertainment claim. I wrote a letter in June after our first meeting together with the representatives from Titan Group. And at that point, I was really concerned about the noise pollution coming from the patio, because again, that is directly in line with my house, my bedroom. Since writing that letter and meeting with the attorney and the representatives for a second time, I just want to reiterate or give my statement of my concern with their pattern of what I call reluctant communication filled with misleading statements. Ms. Tilden has acknowledged this and mea culpa, but I still want to put this on the record. So during the community meeting on June 12th, 2024, this meeting was only scheduled again because the large signs went up, directly across from my house, indicating that there was going to be a hearing on June 18th. This was the first that we've learned of this project. Looking up the project paperwork, it was filed for in February. There was time between February and June to have alerted the neighborhood in some capacity.
Well, I do think we have been made aware
Yes.
of the concerns regarding the communication.
Right. But I want to emphasize that this is a pattern, and I was the one who asked why we weren't made aware, and as Ms. Tilden said today, in her exact words, and said then, it didn't cross their minds. I just find that this, for a organization that on their mission statement talks about being good neighbors and working with the neighbors, I feel like the Titan Hospitality Group started off in a way that was not honest and with integrity. And then I won't go through all of the things, but I have a list of at least 5 things where they have, through the communication with the email chains, to then not wanting to talk to us directly as citizens, but would only want to go through the Hampton Community Council. So business card from James King, great, but they didn't want to talk to us anymore. So that was deceptive. The definitions about acoustic versus amplified acoustic, and again, events. I'm a bass player, I play in bands, and I know that when people who are performing music have control over their sound, it is going to have an incredible variance. So unless there's some sort of standardization, as a neighborhood, we're put on the defensive. to be calling 311, which may or may not respond, and try to get that track record. And that kind of reactive power is not, to me, as important as saying right now that I don't think that this live music approval is a good idea for our neighborhood and for the scope of that.
Isn't it just as likely, or isn't it possible that the live entertainment, again, I've mentioned it before, may not be violative of any ordinances or laws, which would give rise to a 311 call?
Right, that is correct. Now, my presence here today is on the hypothetical that, okay, if they do violate it, I make the call, time passes, it could be violated again, and it just seems like that kind of, again, as I'm saying, like after the fact, harping on something and using city services when I feel that the intent of this or the idea of the event space just doesn't fit the character of the neighborhood. I understand, and I will be using 311 to all my power, but that does not tell me that there's going to be a quick response. So I'm one that I would prefer to nip something, not encourage a problem. The other things I just want to mention is, again, the various statements about like when music would be played, when it wouldn't be played, the changing of the details of the valet parking, the changing of the delivery hours, and just essentially what I think is their willingness to communicate with us. I think it's important to realize that, before I moved to Baltimore, I lived in Austin, Texas. I had a coffee shop. I know what it's like to put a business into a neighborhood. And I know it's really, really important to make decisions that are going to help the business. So I'm not, saying, I don't want them to have the restaurant there. But what I am saying is that the sort of disregard and the misleading of the neighborhood needs to be on record. And I just urge you to consider all of our concerns. We are a small, sorry, I'm hungry, I'm tired, just like you are. I hate the idea of moving into a place to then be driven away. Thank you.
Thank you, ma'am.
Chairman, if I may, just briefly, I am so sorry to see that sort of any of this process has caused such distress, and I think that is sort of representative of the fact that the way that this process has gone is not how it usually goes. Usually what would happen is our team would reach out and say, we're submitting this application. That did not take place. As I mentioned, it was because it's in a shopping center. And generally when we're doing projects in shopping centers, that is not the direction that we go in. I recognize and apologize to this group that outreach did not take place initially. I do, though, want to clarify and emphasize that the absence of outreach at the outset, and I'm addressing this to some extent to the board, but really to this room, the absence of that outreach at the outset was a mistake. The conversation that we had with you all was open, honest, upfront, and candid, which is why hours were thrown out. We did not come with a presentation where everything was written down. And had we would have thought about it and been much more specific. When we came back to you with the response, and I will say it was not, we're going to do 4 to 8. It is, we understand this is different than what we said, but is this an option? And it sounds to me like this has all been colored sort of by the absence of outreach at the outset. But I do also want to clarify that the reason that we try to channel these things through the community associations is because as Blaise, I'm not sure if he's still in the room, did say, there are about 8,000 residents in Hamden, and to field, there's a reason that there are community associations, and the intent is for everyone to work together and provide us with feedback, because it is simply impossible to respond to 8,000 comments on an application like this. We fielded communications with individual residents, I received individual emails and provided supplemental information. I'll note that Mr. King did not receive a single phone call. And so I think this is rooted in sort of a deep misunderstanding that is extremely unfortunate, because I believe that it is not representative of Mr. King's desire and sort of modum operandus. So I'd like to start there. I want to allow, obviously, any other public testimony, and then we'll sort of wrap back up with the legal element of that. But I do think that that's important to put on record. And Mr. King, if there's anything you'd like to add.
Yeah, I mean, if I may, it's frustrating to sit here and hear this about the communication piece. But I will say that communication is a two-way street. And my attorney called me 4 days prior to the first meeting.
Let's do this. I just want to be sure we get through the rest of this.
Yeah,
Yes,
we'll say, wait till the end, absolutely, my apologies.
And then you'll have the full.
Fair enough, thank you.
Of everything that's been testified to. Anyone else?
Yep.
Throw it with you guys up for the stand. That's okay with you.
As long as there's a green light in front of you.
Very well. Need my name, sir? It's Keenan, Keenan. Last name Sperry, Sperry. So take a moment to thank you guys for bearing with us. I know we're approaching 1,800 hours here. I know you guys want to go home just like us. Mr. Fields, I pride myself in being an individual who can read faces and read personalities. You strike me as someone who likes data, someone who likes numbers.
It's helpful.
It is helpful. It is, especially situations like this where you're here to interpret the law, which is very black and white, just like numbers. Is that not correct?
On occasion, yeah.
All right. The proposal here in front of us is to have live music in an open air establishment. Correct? Let's see some quick numbers here. My neighbor has advised us that from the window to their house is about 60 feet. There's about a 20-foot setback from that location to the proposed location for the outside music, or the only intrusion is a tree in the way. All right? So we'll say about 80 feet. I'll extend the courtesy of extending that to 100 feet. I was able to do some quick math. As you guys know, I'm not saying this to insult intelligence or to patronize you in any way. Decibels, the unit we use to measure sound, is measured logarithmically. All right, it's a base inverse. It's used to establish scale. All right. Typically, when we look at a amplified music event, amplified acoustical music event, whatever term you'd like to use, we're looking at about 100 to 110 decibels. That's a lot of noise, okay? That is equivalent to you standing next to a fire engine screaming its siren. That's quite loud if you're right next to it. I want to make that distinction clear. I also want to make the distinction clear that I'm not an acoustical engineer. I'm just someone who likes numbers, okay? So please take that with a grain of salt. With that being said, I was able to look up the Baltimore City Code for noise. It says that for an area zone commercial that abuts an area code residential, the maximum allowable noise per code is 58 decibels, okay? I'll take another moment here to inform you that sound requires a medium to travel through. In this case, it's air. In that case, we look at the law, which is an inverse square. So for every distance you travel, say 3 meters, you lose, say 6 decibels, and that's true for the next 3 meters. From that point of 100 feet from where that music is being transmitted to the 100-foot arbitrary number we've established, we are sitting at 80 decibels. You know what 80 decibels is? It's the equivalent to a blender being run at full power. Personally, I am not able to sleep with the sound of a blender running at full power. I'm not sure if you are, and if you are, more power to you, all right? This is just a short example of what we are up against. And based on the information provided by us for conditional use per City Code 32-5-406, with this conditional use, endanger public health, safety, or welfare. I consider my sleep to be an issue of public health, safety, and welfare, okay? I'm a public servant just like you guys. I'm a professional firefighter. I have to sleep. I have to sleep to do my job. I have to sleep to stay healthy, to protect people who count on me to be able to do my job. All my colleagues behind me, all of us on Elm Avenue, all of us in the Rotunda, have to sleep to stay healthy. With the proposal in front of us, I find that very hard to believe. And these are very rough numbers. They could be louder or they could be quieter. I'll admit to that. But I think it's incumbent upon them to, at very least, I brought information along with this today, and it appears they haven't done so, to provide us with information on what type of volume, what type of music, what type of decibels will be encountered on a regular basis, on a daily basis, on a nightly basis. I think that's only fair. All right. Any questions? Thank you, guys.
Thank you.
Appreciate it.
Table to the podium?
Either one, your choice. Again, as long as there's a green light.
My name is Cody, C-O-D-Y, Samet Shaw, S-A-M-E-T-S-H-A-W, all one word. I live at 3932 Elm Avenue with my wife and 2 children. We've been asked a lot why we're speculating about this harm, right? Why not just call 311? And one of my neighbors has already very aptly said that that's a reaction. And I would go one step further and say, because then the harm's already done. The harm's already done. If we're woken up, then that's it. I have 2 small children, they're 6 and 2. There's noise at night. Already Rotunda Rocks makes all kinds of noise, wakes them up. And you ask, what's been done about Rotunda Rocks? I've looked it up to my as best I can find out. I checked the publicly available permit information. There's nothing there. As best I can determine, not being a full-time zoning department employee or an attorney who practices in the area of zoning law, as best I can determine, it's under a special event permit, and I didn't get a chance to come to a hearing. I wasn't asked. Well, now I am being asked, and so here I am. This is what we're doing. This is what we're doing in response to, we already know what Rotunda Rocks sounds like, and now we're here because we don't want more of it. At the last community meeting, where the appellant and counsel or a different member of the appellant's team were there, I said, okay, we have 100-person proposed event space for weddings, whatever the event is. How is that not a banquet hall, which is not a permitted use? And I was told, well, because not enough of the events, not enough of the total proposed business is dedicated to that non-conforming use. And so really what's happening here is if they wanted to put in a 100-person banquet hall, a non-conforming use in a C2 zone, they wouldn't be allowed. So they've just built a bigger restaurant around it. And I don't think that's an answer to our concerns. And we've been asked now several times, okay, the standard is there has to be an adverse effect. Is it adverse if it's within the decibel limits, whatever the 58 decibels, I believe, is a number that's been thrown out. Again, and I'll just say yes. The answer is yes. The answer is yes. It is adverse. If I'm awake when I don't want to be, then it's adverse. And until the newly renamed Maryland Supreme Court says otherwise, then that's the answer I'm going to give you.
Maybe.
Then
That may or may not be consistent with what the legal standard is.
oh no, I
Because you're awaking. Because it's adverse to you.
it's because it's adverse to the neighborhood, because it results in a change to the character. We bought our house for grocery stores, for the small businesses that not small. I mean, it's a chain. Moby Dick is a chain. I don't mean to mislead. They're not all locally owned. Those are small business, small in scale. Pharmacies, grocery stores, school, preschool. That's why we moved in. That's all going to change if we now have a 270-odd person restaurant, 100 seats of which are dedicated to events like weddings and the rest of it.
So, you know, I mean, I had prepared remarks. I've left them because many of my, I'm trying to only touch. And I will also say, we've heard a lot about what the what the applicant has to say. They want to be a part of the community. They want to do this. It was an oversight. It was a this. It was a this. One of the very first things that the applicant's counsel said when she sat down and began her remarks was, well, we came to the community and we offered this consent. We offered this. We offered this. We offered this. They rejected it. So now all of those proposed concessions are withdrawn and we will adhere only to that which law or the board imposes on us. Okay, that's not somebody coming to be neighborly. That's a hardball negotiation tactic. That's, we were willing to extend all sorts, you know, we'll have all sorts of conversations, make all sorts of promises that maybe you can or can't hold us to. But because we saw we can't hold them to that, we get one shot at something that's enforceable. We get one shot at something that has teeth, which is this. We said, no, we want to go through that. Now, well, no. Now it's all off the table. Now we will only adhere to those, you know, it's all gone. Any concessions that we claimed we were willing to make, that's all off the table. Okay, that does not inspire faith in us. That any representations they've made about, well, it's going to be this kind of music, it's going to be a jazz trio, it's going to be this, it's going to be one singer, whatever it's going to be. That does not inspire faith that these are credible representations, that the occasional call to 311 is going to resolve. So in terms of ad hoc remarks, I think that about covers it. Thank you.
Any questions for the witness?
I think that's it for the opposition.
Yeah, I have questions for the applicant. Is this a good time? Okay. So questions for the applicant. In the event space, what are the hours of the event space use?
So the event space is dictated somewhat by the events we book. If it's a bar mitzvah, if it's a wedding, if it's a graduation party, the hours are identical to the restaurant hours. So we'll never have an event outside of those.
Can you just refresh my memory? What are the operating, like the closing time? I know we
Yeah,
talked about the days.
So 11 a.m. to 1 a.m.
Okay.
Just to address that point related to your question, I heard a lot of what if. We actually have two of these restaurants up and running in Columbia and Gambrels, Maryland for the last several years. We know exactly what they do. We know what their sales are, and we know what the breakdown of private events to restaurant to bar. We know food sales versus alcohol sales. This isn't a big what if or how this may work. We actually have concrete examples. Our private events are 15% of total revenue at both restaurants. It's not 50, it's not 70, it's not 80, which you would, if you listen to the testimony today, you would think.
Mr. King, just to clarify on that 15%, what does that look like in terms of days out of the year?
Well, if it's December, it's 25 days because it's holiday parties. If it's August, it's 1 or 2 days.
Right.
It
I'm
just
trying to
depends seasonally.
apples to apples from the neighborhood's concern that was saying infrequent on Fridays, and then you say 15% of the total business. So I'm just trying to
So,
find.
yeah, it's really hard.
alignment.
There's wedding season is spring and fall, so we don't do a lot of weddings in June, July, and August, but we do in September, October. Obviously holiday parties are busier than in January when there's nothing going on. So it really is very seasonal. But again, I also want to make the point, we hear a lot about the community and where it's located. In Columbia, the Blackwall Barn and Lodge is located under 6 floors of apartments. We're the ground floor of 6 floors of residence above us. We are directly across the street from another building that has 6 floors of residence. In Gambrels, we are directly across the street from 25 homes.
Understood. I've got a couple of like really quick
Sure,
questions, and
absolutely.
then that way we can just be really efficient. Will the event space have a dance floor?
Yes.
Okay. And then I'm assuming because you've had the same restaurant program in other areas, especially doing what looks like a similar build out, when you've done the sound testing at these other locations, what is the average decibel during your sound testing?
I can get you that information. I don't know off the top of my head. Our architects and engineers work with that, but I'll be happy to get you that information.
Great, thanks. Let me just look at my notes real quick. I think that's it on my questions for right now for the applicant.
Question. With regard to the design of the space, and looking at where the event space is to be located, which is towards the back, the rear, and in this situation would be, I guess, the portion of the building that's more directly across from residents. Is there any thought given, or is it even a consideration to move the location of the event space? I'm not an architect, not designed restaurants, and don't know how awkward that is or whether or not it's even feasible, but to have the event space away from the end of the street towards the center of the square.
We looked at all different locations, setups, diagrams of how to make this space work. That was because of the age of the building, the materials it's built out of. And keep in mind, this is an old concrete building that has walls that I think are about 3 feet thick. We heard about the blender. I hear if a blender's next to you right here, it's loud. If it's got to go through 3 feet of concrete, across the street, through your front door, past your heating, up your steps and into your bedroom, it's not still at 58 decibels, right? And so that building is going to be a pretty thick, plus noise buffering.
And in terms of the event space, is that open air
No,
back there?
all enclosed within the building.
Well, that's, I think, was not clarified in the entirety of testimony that we've heard. So enclosed how?
It's inside the 4 walls of the building. The private event space is inside the building.
That's roofed, right?
Okay.
If I may, there are
No,
glass.
no, you mean not yet. So there's a rear patio to the space?
There's a side patio
Side
to the
patio.
space.
Yeah, so
This drawing here.
the floor plans are a little bit more helpful than the renderings.
Okay. But you're not envisioning open air space with live entertainment in the rear of the building?
On the side of the building between 4 and 8 o'clock, but not in the rear of the building.
Okay. What about with regard to the events that may occur? Special events, would it be live entertainment beyond that 8 p.m. open air?
Potentially, if it's a wedding.
Entirely indoors, though.
Yeah, all indoors, nothing outside, nothing exterior.
Okay.
The hours of the live music interior will be dictated by the event that we host, the hours of the event. It's an office Christmas party or.
But as I understand your testimony, there would never be a situation in which an event that went to 1 a.m. or even midnight would include live entertainment outside open air.
That's correct.
Outside live entertainment will be limited to between the hours of 4 p.m. and 8 p.m., Monday through Friday.
Will people that rent out the event space have access to the outdoor area? Like, can you rent out the outdoor area in addition to the event space?
We probably wouldn't from an economical standpoint. But somebody potentially could rent that out. We just wouldn't be able to give them live music out there and, but yeah, I guess if somebody wanted to have a luncheon out there, or, we would look
I think
at
what I'm trying to envision in just sort of response to some of the things that we've heard from the opposition. So we're having a wedding, and then everything's happening indoors. you'll have a lot of times at event spaces, you'll have sort of spillover. Like people will leave the event space and they'll want to gather on a patio or they'll want to gather outside. And so my question to you is, when you contract with people that are renting the event space, do you restrict where they can be, or do you allow them to go onto the patio, or is the patio like literally treated as part of the restaurant, and so when the restaurant ends, the patio ends?
That's the last statement you made is correct. That being said, we do treat it as the restaurant. If if a wedding were to end at 9 o'clock and everyone's leaving, if 6 or 8 of those people decide, hey, let's go to the patio bar to have a drink, or the patio and sit down and have appetizers, it's treated like the restaurant. We wouldn't say no to that, obviously. They can go where they want, when they want, but it's not as if, we don't say you can only go in this section right here when the event's over.
One of the things that came up from the planning department in terms of their letter and recommendation was, to piggyback of what you just said, is saying that users of the outdoor patio need to be seated and served. Is that your intention, even when there is an event program happening in the event space?
I just want to make sure I understand your question. Is the intent to, are you
Let
talking
me
about the patio or
rephrase that, 'cause it was
the
kind of
event
clunky.
space?
So the planning department director, in their letter that they issued, said, we would support this application with the following conditions. And one of the conditions was that the outdoor space only be used similarly to a restaurant, right? So that every user of the outdoor space, there's no outdoor bar, there's no standing around, you have to be seated at a table and being served. Does that fit with the way that you plan to use the restaurant, or would that be a condition that you would have to adhere to or change your operations?
No, we would adhere to that. I mean, we had always envisioned having a bar out there, but if they said no, we're fine taking the bar away.
Okay.
That's not a game changer for us. For us, the outdoor patios to activate the space and have people have an opportunity to be outdoor dining al fresco, which is very popular since COVID. It doesn't really matter to us whether they're seated at a table or chair at a bar stool.
All right, thank you.
Okay, we interrupted you.
I'll let my attorney rebut a lot of the things that we heard today. I just wanted to make a personal point, Mr. Chairman and members of the board, that on the communication piece, facts matter. And I was notified 4 days prior to the meeting at the Rotunda that the community wanted to meet. I moved my schedule around. I said, great, I went. I handed my business card to every single member that showed up that has my personal cell phone number on it. And I said, every one of you are welcome to call me 24/7 about anything.
He handed
To
as
this-
many cards out as he had.
I went-
on his
They were all
person.
gone. To the point they were taking pictures of my business card because I was out of cards. To this day, I have not received a single phone call, email, or text message from anyone in this community. I was notified 4 days after that meeting that they were going to oppose it. I offered everything from hours of operation, of deliveries, of construction. They gave me input on what color the building should be. I agreed to virtually everything that they wanted to, and then I found out several days later that they were going to oppose it. But again, no further dialogue on their part when each one of them had my personal contact information. And so communication works two ways. There was a lot of communication about, why didn't we communicate better? We didn't communicate better because, quite frankly, we're still in the preliminary phases of this project. When we do go into a new community, we do communicate. We do build relationships. We do go door to door. We haven't picked up a paintbrush yet. We're still working through permitting. We're still having zoning hearings. We haven't gotten to that yet. And so I think they will find out if they talk about to the people in the communities that our restaurants are located in, we are well respected. We are liked. We support that community every single day. And so, after sitting and listening to that, it's tough because we work so hard to become good members of our community. So I wanted to be on the record for that. We heard a lot about sewage backups. I don't know how it's related to my live music license. We heard a lot about 311. I don't know how it's related to my live music. We heard a lot about a lot of different things today. I would just reemphasize that ultimately, at the end of the day, we believe, when we had the meeting with the community, and we're here to talk about live music, there was live music outside blaring, right? And they're protesting live music indoors. So, it's just hard to understand how, we've done what we thought we could. Maybe the communication could have been better. I'll own it. I think leaders own those mistakes. But at the end of the day, it is a two-way street. And I've put myself out there to communicate with anybody in the community about anything. So I appreciate your time. I know it's been a long day. I'll let Drew finish up. I'm sure she has some points she wants to make. But thank you very much for taking the time to hear all that.
Yeah, absolutely. So I will be quick because we've all been here for a very long time, but I do want to just go back to the legal standard. I appreciate that I have Mr. King here to sort of share the operation and his business background and how he likes to operate his restaurants. But I want to emphasize this is a conditional use application. The legal standard for conditional use is there an adverse effect of this use at this location above and beyond what is inherent to the use anywhere else. So we're not comparing it to another use in the same community. What we're looking at is if we take this use and we pick it up and we plop it at another C2 zoned property, are the adverse effects on this property worse here than they would be at another C2 zoned property? Is there something about this use at this property that is making it worse than it would be anywhere else in the district? And there is nothing on record to that effect. I also want to note that I think there's a little bit of confusion about the nature of what the C2 zoning district is supposed to be. The C2 zoning district is a community commercial district. It is designed to be located near R6, R7, R8 high-density residential. You will not generally see a C2 district that is close to a lower density residential, which it has kind of been implied would be a better fit for something like this. And accessory live entertainment is actually only even a use that could be approved conditionally in the C1, the C1VC, and the C2 districts. Those three districts are designed to be adjacent to R6, R7, R8, multifamily or single family or multifamily residential, row home residential districts. So if we take a look at what it has been asserted would give rise to adverse effects above and beyond the inherent use, what we're really hearing is that it's adjacent to a residential property. And that is what the C2 district is designed to do. And there are C2 districts all over the city, one that I was recently here before you discussing, that is also adjacent to row house residential districts. That's what it was designed for. So to that effect, I assert that this is consistent with what the city council intended when they designated this use to be conditional. When zoning the property C2 and passing Transform Baltimore. I also will emphasize that what Mr. King said, we're not here about sewage. This could be a restaurant of this capacity by right with the same sewage impact. We're not here about parking. The parking is by right. We're here about the accessory live entertainment, and again, there's no evidence on the record demonstrating that this use is going to give rise to adverse effects above and beyond those inherent to the use in the C2 district. Thank you.
Any other questions for the applicant?
Yes. To Mr. King, thinking about some of the concerns that folks have had, would you be amenable to a condition of approval that would require the use of the event space during the weekdays, not excluding Friday, obviously, ending a little bit earlier than 1 a.m.?
I think that would have an adverse business impact during the holiday season, during wedding seasons. And so we're going to make a construction investment of $4 million, a capital investment of over $7 million. I need to make sure that I can protect that investment and pay the bank note and pay the landlord. And so I'd be hesitant to put any restriction on that that could adversely affect our economics.
So for example, if the board decided that this use was conditional on the event space, not the restaurant, just the event space for private events, ending, say, 10 PM, Monday, Tuesday, Wednesday, Thursday, or Sunday through Thursday. Would you be amenable to that? Not the restaurant, to be clear.
I would say that I think 11 o'clock would be more reasonable for our business model.
Okay.
You know, we have a corporate party, business that wants to have a Christmas party, they typically book it from 7 PM to 11 PM.
Okay.
You know, do I need 1 AM on a Tuesday? Absolutely not. I'm not worried
Okay.
about that. But as long as it's reasonable and fits within what we get as far as business functions.
Okay.
And again, event space being enclosed
Mhm.
by whatever size, thickness walls there are.
I mean, you know, you never want to handcuff or hamstring your management team or your sales department in a business model, right? But at the same time, I don't expect to have private events at 12:30 on a Tuesday night. So it's, you know, again, looking for a reasonable standard and working with the community, I would be open to something like that, but as long as it doesn't hamstring business.
Also, the board can impose whatever conditions that it sees fit
Yes.
and doesn't need the applicant's
Correct.
permission to do that. Also, just to note, some of the microphones are dying of no batteries, so if there's no light on at all,
Sign.
that means that it's not working. So I can play musical microphones with you if you need a microphone that works.
I guess this is a question for the chair. Well, I guess you ask us, but my question is, are we prepared to vote on this today?
I'll raise an issue with regard to that.
Okay.
In terms of the board's prior rulings, again, there was an issue or case that was mentioned, 4001.
Oh, I'm ready to talk about that if you want me to give you the background on, it's a totally separate, different property.
I do.
Okay,
I do want to hear that.
but you also want to
but I
read
don't-
the,
But
You
I'm
wanna
not
hear
sure
it.
that we're ready to
okay.
tonight, so I don't necessarily need to hear it right now.
Oh, you, okay. It's up to you.
Unless- I mean, how you feel, Dave.
I mean, I'm kind of in agreement. I don't think I'm ready to vote on this. I actually like to
Take, consider
ponder
some stuff.
these notes and look into something myself, actually.
Now, if you want to put that on the record since it was raised,
Sure. I'll just briefly summarize it, but then I'll give you the resolution so that you can look at it later. So this was 4001 Falls Road. This was heard November 2021, so quite a lot longer ago than last year. And it was about a Redfish Liquors, if you know where that is, was proposing a restaurant in where the current liquor store is. And there were some dilapidated garages in the back that they were hoping to renovate and use as karaoke, individual karaoke rooms, like 9 of them or something. And the board denied that live entertainment use in that specific location because of where those garages are located and the sound that people were concerned about, as well as other issues like parking. There was absolutely no off-street parking there. So it's a very different kind of application, but I'm happy I'll share that with the board so you can take a look, and I'll share the whole file with you if we're gonna take some time on this one.
okay. Great. I agree with my colleagues that I would like to review the record a bit more, including, some of the exhibits and notes on the testimony, and then we can reconvene whenever we reconvene, we can deliberate. It could be as early as, the next hearing, which would be on our general meeting agenda for deliberation on this matter. So happy to do that. Okay,
Sounds good.
thank you all so much.
Thank you very much.
Hanging out with us.
Did you say 6:10? Is that what you said?